Petitioner who are continuing lecturer. I think now the principal of the college, without following any procedure, issued a letter to terminate that service by 31st. By 31st. Without following, without any so good.
See, MSFC matter members. Stage operating against members. Stage operating against members. Immediately. They have to
petitioner is retired from service. After supervision of proceeding is not permissible. Similar judgment has been passed by this honorable court.
When it was?
When did he retire? Retired in June, my lord, not getting retired benefit because of pendency of the proceeding.
Within 1 month, who will give you the retirement? Have it come to do. Yes.
My lord, the petitioner is, has already been retired. She has filed this petition for her promotion from the rank of principal to urgent matter. She has observed
technical matter. The order of this honorable court is not carried out. Therefore, first content was filed. Direction was made for compliance within 1 month. That is not carried out. 2 years have passed.
My lord, the petitioner Richard.
Part of the mention was this matter regarding to disengagement matter. This matter regarding to disengagement matter. Your lordship already
When it happened?
in the July, my lord.
Take it after 2 months.
This matter
Your lordship posted to today. Your lordship similar matter posted to today, but that matter not been listed, my lord.
Not listed.
My lord.
Let it come. Let us.
My lord.
matter relates to third MSCP, my lord. Which was posted to Monday, my lord. Third MSCP Ashok Mahapatra matter.
Similar matter.
Yes, man. Let me listen on that one.
One matter is
Based on one day.
Termination matter, my lord. My lord, termination matter, my lord.
my lord.
We said one matter Monday. How we will remember it as Monday? Asking to write it on Monday.
Yes, my lord.
One matter is special urgent today.
Termination matter, my lord.
Listed, my lord.
Not listed. It was urgent by whom?
My
Other
lord.
bench.
Other bench.
Some it
My
will
lord, termination matter, my lord. Most urgent termination matter, my lord.
Urgent matter. Despite the my lord consent given by the parents, the principal KV could not issue transfer certificate in favor of the minor child.
take it tomorrow.
My lord, it's pension matter. The petitioner retirement after 2022. My lord.
Retired on 23.
This happens only in the fish market. Mainly, you are all members of the bar. So one by one, I'm hearing everybody. Don't create fish market in the court. Yes.
My lord, pension matter. The petitioner after retirement but not getting his
When he
pension.
retired?
2022, my lord.
Without 22. Call up to court. Yes.
23 matter, my lord. Termination matter.
23.
23.
Call up. Write down. He will not know. What kind of court staff you are? So substandard.
Arrest.
Basically means
Revise assured career progress, my lord.
rare progress.
Yes,
2
Mr.
weeks.
My lord, this is a service matter.
2 weeks. Write down in every memo. You cannot remember. Afterwards, you make my court to a big fish market. Yes.
My lord, this is a service matter of fresh admission 2023. In this case,
After 2 weeks. Yeah. Right from
The petition has been
increment. I don't never treat it as urgent matter. 3 weeks.
petition has been filed for seeking reservation under PWD quota.
PWD.
Yes, for promotion.
The recruitment happened when? You have come without reading the file. Take it next week.
Lordship, this is a matter we have challenged. The order of the Pollution Control Board has revoked the consent to operate.
When it was revoked?
It was revoked in March, but there is
I was asking a date. When it was revoked?
it was they had ordered a notice as a stay order operating on behalf of me.
Stay operating.
The Honorable Court was directed to do a subsequent inspection of the stone quarry. It has been conducted, but the report has not been submitted, and
We have interim order.
we have, but we want.
Leave it. Please. Pension terminal benefits not given.
Not given.
When rate?
23.
Take that next week.
मैं लड़ एक सर्विस मैटर है हाई स्कूल कॉन्ट्रैक्टर टीचर का ये नोटिस गया है उसके बाद डेट देना है
Who is your lawyer?
आई एम वांट टू इन पर्सन
I want to argue in person. Give him some day. So that, to which place you are coming from?
I am from Khordha, my lord. I am from Khordha.
Yeah, how many kilometers?
It is 70 kilometers.
70 kilometers.
70.
Give him some date next week. Give the date so that we can come there. Still you are certain. And then come.
Okay.
Okay?
God bless you.
Tell him the date. Date. 6-8.
Page 1. Page 1, my lord. Page 1, lord. Item 8, item 58 and item 59, my lord. They are similar matters. Lead matter has been adjourned to 5th of August 2025.
Call the serial number 8 and serial number 55.
8, item number 8, 58 and 59.
58 and 59. On.
My lord, the WPC number is 32208 of 2023. That is the lead matter.
The date.
5th of August, my lord.
Call on 5.
Lordship may tag the matter.
How? There is no order, na? For tagging. There should be order sheet.
My
May I please, your lordship?
Yes.
Recruitment matter. Petitioner has scored more marks than the last selected candidate.
When it happened?
April, my lord.
In April. Call up for 2 weeks.
My lord, I may be pardoned to make a mention, my lord.
Yes.
My lord, this is a matter under rehabilitation and assistance scheme. Matter of the year 2023, my lord.
23.
My lord.
Call up. After 2 weeks. Yes.
My lord, another matter is
One lawyer, 1
24, my lord.
24.
24. This is the matter, similar matter, my lord.
Similar matter.
Similar matter.
Same day. Both same.
Date may be fixed.
No. Yes. Okay. Yes, sir.
Page number 7, your lordship.
Page 7.
Page 2, page 3, page 4, page 5.
Page 4, my lord. If your lordship permit, it is an orders matter, item 55, madam.
55.
Yes, madam.
55 is a page 5.
You want time?
55, my lord, I am for the opposite party.
What you want?
Oh, my lord, I am filing the objection today. I am serving a copy. Your lordship, keep it Monday or
Call.
I will intimate the other side also.
Inform the other.
Yes, madam.
Call this that one Monday at the request of panel.
And I am filing the lordship, I am filing the objection today.
That we cannot now say that. You will file it. It will come. But the delayed objections.
No, delay.
We will not enter.
No, it is fast date.
There
It
is a
fast
time
date.
period for filing of objections. Otherwise, we will take the answer of the petitioner as true and correct.
I have filed the counter affidavit. A IA has been filed thereafter for amendments. I have filed the objection today only in the registry.
Page 7, 62 to 65. Page 8, 66 to 72.
My lord, item number 68.
6.
My lord. My lord, the counter has not yet been filed by the state. This matter basically pertains to the regularization of the
What you want?
the counter.
When it reaches, you can mention.
72, madam. Item 72. Ma'am, taken
We have no power to direct the respondents to file the objections. Can the court direct the defendant to file the WS? No. We will decide in the absence of that. You can take advantage of that. Okay?
72, madam. Maybe taken from next week, Mr. Das is out of station.
Which one?
72 item.
72.
Madam.
72. On request of counsel for the petitioner. Petitioner.
Page 9, 73 to 79.
Lordship, item number 74, I may be permitted to withdraw the matter, Lordship.
75.
74.
74.
Pratikya Singh Samantrai, WPC number 17211 of 20.
Why not happy with the court?
Your Lordship, the petitioner is not interested in pursuing the matter anymore.
Learned counsel for
I'm filing a memo to that effect.
Learned counsel for the petitioner writes a memo dated so seeking leave of the court to withdraw the petition without disclosing any details. First comes. Next correct. In the above circumstances, the matter is disposed of as having been withdrawn. First, judges need to send a copy of this order to all the respondents for their filing. Leave to withdraw is without leave to litigate on the same petition. Brings me to send a copy of this order. So,
Much obliged.
Item 1.
Please, Your Honor. Yes, the claim of the petitioner for pensionary benefit has been rejected under Annexure 8, my lord, on the ground that
number 1 it is.
the ground that husband of the petitioner was block grant employee. The Hon'Ble High Court in the case of my lord Giri and others, in fact that there is no distinction between block grant and full grant.
Similar matters, we have
Notice this.
on which date?
Item 2, my lord.
Yesterday, item standing for Mr. So-and-so is requested to accept notice for the respondent on this matter. On which date we have posted those matters, identical matters? Yesterday, they were no serial number 22 or something. Yesterday's item number 2. On this matter along with that. Okay. One sentence you have to read. Heard, Learned Advocate Shree. So,
Item 2.
You're also permitted to withdraw. Liberty to file better.
Any reason?
No reason. Liberty to file better application, my lord.
Better petition.
My lord.
Petitioner's counsel has moved a memo dated so which reads as under. Where is your memo? You will file now. Please be exact. First, in terms of next paragraph, in terms of memo, legally in accordance, the petition is permitted to be withdrawn with liberty to relitigate on the same cause of action in accordance with law. Next.
Item 3.
Give one paper to me. Whoever wants to withdraw, give one paper and 100 rupee note also. Yes, brother.
Petitioner praying for a regularization of service. My lord.
How many years of service he has put in?
Since 2007, Your Lordship.
2007.
7.
Umadevi came in 2006.
2006.
Whether Umadevi comes in the way?
Here, my lords, this is a case. His service will be regularized after he got eligibility. One exam he has to pass that. After that, that is requirement.
That he has not done. Have you passed the
He has
examination?
not done. My lords, kindly see page 80. 80.
Your Lordship. Lodged by rejection.
Last para. In view of the above, the petitioner should not have requisites
After the occurring the requisite qualification.
Right.
What is that requisite qualification?
that he has to pass OTAT exam, that is one.
Not rejected.
Your Lordship. Your Lordship, kindly see on page 82, Your Lordship. 82.
A2. What is that A2? What is exam?
That exempts that exams.
Exams.
Yes.
Then why are you insisting upon examination?
My lords, this is by Directorate of Elementary Education. But this notification under Annexure 9, it is under the STSC Development and Department, my lords.
No, why
And
there are
here there is a stipulation.
No, but inconsistent notification.
My lords,
One notification says examination. Another says
this is subsequent. My lords, the other one is subsequent. This is 20 and
Annexure 9 is subsequent.
Annexure 9 is subsequent.
Yes, Your Lordship.
9 requires the examination.
My lords.
Yes.
10 practice examination.
Exempts.
Then this order cannot be sustained.
My lords, that is by different departments.
That makes no sense.
My lord,
All departments, Supreme Court said, all departments are parts and limbs of the government.
then I will file counter.
You want to file counter?
Yes.
You can reconsider this. We'll
Yes,
say,
Your
in
Lordship.
the light of subsequent notification, you have to reconsider the
My lords, they have taken note of the
notification also. Then issue notice. Issue, heard, Learned Advocate say so and so. Case is made out for issuance of notice. First, issue notice. learned DGA on request accept notice for all respondents. All respondents. Give a copy of the petition. You have given already?
Yes, yes.
The short point, we'll call it after 3 weeks.
My lord.
Okay?
Items.
Since matter lies in a narrow compass.
4 weeks.
Item 6. May item 6 yours.
6, same.
Sir.
Same order. Don't mislead me.
Yes, sir.
Lawyers.
Yes.
But I remember also.
Yes.
Yes. If somebody misleads me, he will have much difficulty.
My lord, senior will
Just request you. Don't mislead me. Believe me. I believe you.
Yes, sir.
Don't mislead me. 6. Same order.
Item 4. May I please proceed?
Yes.
But here I have challenged the termination order under Annexure 9.
31/3/21.
31/3/2021 and the order of the collector rejecting my appeal in 2024.
On what ground you were terminated?
My lord, I was engaged as block resource teacher.
Teacher, which effect from which date?
My lord, I was appointed on 22/2/2011 after facing due process of selection. My lord,
2007.
22/2/2011. 11. At the time of, my lord, when advertisement was floated, the qualification prescribed for the post of block resource teacher is one must have passed +2 examination and DED, Diploma in Elementary Education. Since I have completed 2nd and 3rd semester of diploma examination, I furnished an undertaking before the authorities that
you will complete that.
That I will complete the same and I will produce the certificate. And accordingly, I was given engagement order on 22/2011.
Where did you tell them that my educational qualification is less than what is prescribed?
My lord, at the time of submission of application, when I was selected at the time of submission, way back in the year 2011. So therefore, my application was entertained and I was selected. I joined on 26/2011. After my joining, when I produced the certificate, and after long lapse of 8 years, on 6/11/2019.
Now they say that you did not have qualification.
Yes. On 6/11/2019, a so-called notice was issued to me. I submitted my reply. Why not get off?
My lords, the certificate produced by the petitioner is found forged.
No.
It was not genuine.
Not genuine.
No. My lords,
From whom you have ascertained?
My lords, from the university which has issued the certificate.
Show that. Where is that?
My lord,
have you filed objection?
No, my lord, first time it has come.
First, after 1 year.
I have annexed the certificate.
No, you have annexed, but their version is it's not a genuine certificate, if not forged.
My lord, they are not taking that plea. You will also be
emergent notice.
Yes.
Admission matters more than a year.
No, impugned order was passed on 8/11/2024. 8/11/2024, it was numbered in 2024.
Admission matter should come within 3 months, 3 days.
Yes, yes.
Issue emergent notice. Learned standing additional AGA is requested to accept notice for all respondents.
Let me tell you.
Which respondent?
All respondents.
All respondents. Okay. Matter lies in a narrow compass. Call in the first week of September 2025. Yes. They bring one judgment. Where initial appointment is given, even without qualification, but with the understanding that he should complete the qualification thereafter. If he completes, he cannot be.
Yes, yes.
There is justice.
Justice Raghunath Misra.
Precise judgment. Maybe.
Yes,
that I have.
Some judgments are
very good. Very nice.
Item 5. Here, my lord, the petitioner pays for division of his pension.
Division of pension.
Pension as per last paid run.
LPC is of which year?
This is of 2010.
The last paid run is what?
Last paid run was calculated in the year 2024.
When you retired?
I retired on 2010. Thereafter, by then, my pension was fixed in the Ashton teacher scale of pay.
Yes.
Thereafter, I filed a case before this honorable court that he should get a headmaster scale of pay as he has discharged the duty of headmaster. And that was allowed. That was allowed in the 2022.
Where is that judgment copy?
Yes, I have quoted that judgment.
You have not produced it.
Not quoted. I have quoted in page number 3. The relevant portion I have quoted.
Page number 3.
Yes, my lord.
10/4/23 order.
Yes, paragraph 9. In last year, Lordship, you can see, having had the learned counsel for the parties and after going through the materials available on record, it is found that due to the relief of the earlier headmaster.
Yes, brother, para 10 at page 4.
My lord.
Appears to be a case. Who will present the
I pray a direction may be
requested to subnote. Issue notice. Community is requested to subnote.
I pray the direction may be given to the secretary and the director where my case is now pending for revision of scale of pay. My school has said that, and the BO has provided the same to the director, and now pending with the government. So
that director consider your case, it will be over.
I think that may be considered.
Page number?
Annexure 4 is pending now.
Annexure
4. That is
this is the recommendation of block education officer.
This is the headmaster has calculated the revised scale of pay, and thereafter block education officer has recommended the same. Now
for revision of your pension.
Yes. That is now pending with the director.
Brother, you consider it.
My lord.
Sit down. Please be seated.
Yes.
After argument, don't expect that court should tell you to sit down. It's your right to sit down. Kindly sit down. If I want to ask any question,
no seat was here.
Right. The short grievance of the petitioner retiree is as to non-consideration of the recommendation of the block education officer, headmaster of the school concerned, countersigned by block education officer of the jurisdictional area, whereby a recommendation is made in his favor, a copy whereof awaits at Annexure 4. First up. Next paragraph. Learned counsel for the petitioner submits that pension is not a bounty in the light of decision of the apex court in DS Sakara versus Union of India. Semicolon. His client had worked as which post it is?
He retired from the post of headmaster.
Worked as headmaster and debited it on superannuation as such, and therefore the last pay drawn should be the basis for computation of diurnal bonuses. Question. That having not been done, and the pension having been underfixed, he is knocking at the door of the court. First, next paragraph. Learned AGA on appearing for the answering respondent, opposite parties, opposes the petition, contending that though right to pension is an enforceable right, the same is conditioned by the norms that govern the grant of the pension. And therefore, petitioner has to wait for the decision to be taken on the recommendation of the headmaster, which is countersigned by the BEO, as mentioned above. First up. When a coordinate bench decision is drawn to his attention, why the order dated 10/4/2023 in petitioner's WPC OAC number 3887 of 2015, learned AGA submits that the consideration would happen even after taking note of the said decision. First, he also tells the court if a reasonable time is granted, there would be no difficulty for consideration of the recommendation in question in the light of what has been pleaded in the petition hearing. First, this is a fair stand. Next one, in above circumstances, this petition is disposed of with a direction to consider Annex 4. The recommendation at Annex A4 dated
18/3/24,
keeping in view the decision of the coordinate bench referred to above, and in the light of the pleadings of the petitioner in the WP, in accordance with law, and further to inform the result of such consideration to the petitioner within an outer limit of 6 weeks, filling which it is of liberty is reserved to the petitioner to move an appropriate application for summoning the concerned officials and take punitive action, which may include the levying of heavy costs personally paid by the There's now no costs. All contentions are applicable. All contentions.
Item 7, Mayor, please election.
Yes.
Item 7 is relating to the upgradation of grade pay of employees of Odisha Adarsha Vidyalaya, especially physical education teachers. In this matter, state has already filed a counter affidavit to your lordship. So I need to reply the same. Because last week they have served me the copy
What
of
do you want?
to the rejoinder, your lordship.
No, if you tell why, you will save another 2 minutes of hours. Call this matter up to 3 weeks at the request.
Other prayer, your lordship. Similar matters are pending for this.
To file the rejoinder to the counter filed by the AG, filed by the official respondents.
The similar matters are pending. The honorable pleadings are already complete. I have called the mail.
Call this matter along with the RWA numbers.
Great.
Item 9.
Yes, brother. Yeah, 9.
My lord, in this case, Annex 9, my lord. The proposal, my lord, for release of
9 page number.
Page 25, my lord.
Both the my lord.
For release of arrear salary for certain period, my lord, is pending, and the headmaster, my lord, already prepared the bills, my lord, and submitted to the district education officer, my lord.
For the period between 7/6/94 to
my lord. 7/6/94 to
February
2001, my lord. Pending before the appeal partner of 2, my lord.
OP number 2.
My lord, director.
Yes, brother, you consider. My lord. The short, the petitioner, an employee of the public service employee, for ventilating the grievance as to non-consideration of the recommendation made by the district education officer Khorda, dated 31/5/2023, whereby he has favored for the consideration of petitioner's case for payment of arrears of salary during the period between 7/6/1994 and February 2001. First, learned counsel for the petitioner, please be seated. Learned counsel for the petitioner submits that the salary payable to an employee is his property, and therefore the same cannot be withheld for indefinite period of time, more particularly when the jurisdictional officials have recommended for the release. First. Next one. Learned AGA appearing for the official respondent opposes the petition, contending that disputed facts are involved and therefore petitioner be relegated to the educational tribunal. First of all, having so contended, now he agrees with the suggestion of his court to instruct his jurisdictional clients to look into the grievance of the petitioner in terms of pleadings in the petition and in the light of the recommendation of the district education officer, a copy whereof avails at Annexure A, Annexure, what is this Annexure?
Annexure 9, Miller.
Annexure 9. Within a reasonable, within a period of, within a reasonable period. First half. This is where. Next paragraph. In the above circumstances, the petition is pulled off and time for compliance being fixed at 3 months, which would include the duty to discharge of duty to inform result of such consideration to the petitioner. Next paragraph. It is open to the petitioner to produce it is open to the jurisdictional authority to solicit any information or document from the side of the petitioner as are required for due consideration of his case. So, however, in that guise, delay shall not be brooked. Now, no course.
Item 11.
Yes.
Well, in this case, my lord, the petitioner for engagement of a guest faculty teacher, my lord, being a ex-guest faculty teacher, my lord, has already approached before the authority, my lord, by the Annexure 4, my lord, before the opposite power not 2, my lord. For engagement as a guest faculty teacher, vacancy is applicable, my lord, and the same is pending, my lord, before the opposite power not 2, my lord.
What is your right to appointment?
Guest faculty teacher, my lord, for certain period, my lord.
How many years you had worked earlier?
I have worked, my lord, 1 year, my lord.
1 year.
1 year.
Where is your right then? Because you have worked for 1 year, you should be taken to the job.
I have no right, my lord. I have no right, my lord, only for consideration, my lord.
Consideration, correct. Right to consideration you should have, na?
Because you have, my lord, because I am a experience and already rendered 1 year service in that institution, my lord, and also having good records, my lord.
No, you may be excellent person even in Devaloka, but question is, what is your right to consideration? Any standard book on writ jurisdiction like B.L. Ansaria, one time he was your judge also. He has written writ jurisdiction published by Indian Law Institute. He writes, right is a precondition for maintaining the writ petition. Nothing. The short grievance of the petitioner who claims to have worked as a guest lecturer at one particular time for a short period is as to non-consideration of his representation for re-engagement of his services. First, after notice, learned counsel, learned AGA, appearing for the respondent, opposes the petition contending that no right, no rate, RIGST, WRIT, is the rule of constitutional jurisdiction, and no right having been demonstrated before the court, writ petition is not maintained. First, I agree with this. Since all standard books like B.L. Ansaria on jurisdiction echo the same. First, in the above circumstances, petition being divided up is dismissed. First, however, dismissal will not come in the way of the concerned respondents taking a decision on the pending representation of the petitioner in accordance with okay. Instead of dismiss this court. Yeah. No worse.
Item 12.
Writ jurisdiction. See, writ jurisdiction, if you see the Constituent Assembly debates, especially D.T. Krishnamachari, B.N. Rao, the constitutional advisor, and others. You to approach the constitutional court, why are you disturbing all through both you are disturbing? What is the requirement? Court officer, sir, what is the requirement? What is the difficulty? How to conduct the case if somebody, we are requesting the lawyers not to disturb. You are seeing that, but you are disturbing the court proceeding. If you have any difficulty, you can mention to me. Yes. Communication. Yes.
Madam, it's a matter of regulation of a Ganashikshak minor. This is a matter of regulation of a Ganashikshak minor.
According to Gana Shikshan. How many years of service he has put in?
Like, he has entered into service since 11/5 May 2008.
11/5/2008. No, your regulation is not.
Though government has one notification there for regulation.
Annexure 8.
Annexure running page 28, my lord. Running page 6, annexure 6, my lord. Annexure 6, running page 28. Running page 28, annexure 6, my lord.
This is government notification.
My lord. According to that, most of
Can you put on one light? Because it is expressing here that not able to. The level is less. This light you can stop for the. We have completed 8 years of regular and continuous engagement.
My lord. Also, I have qualification, my lord.
What qualification?
One clause 2, according para number 2, my lord. There is clause 2, which is deployed in elementary city. That is also obtained, my lord.
Now what they say?
They are saying they about OT8, my lord.
Means
Orissa teachers education test, eligibility test, sorry, eligibility test.
Orissa teacher eligibility test.
Orissa teacher eligibility test. Learning page 20, that I have not done.
Then if rules prescribe that.
My lord, running page 29, para B, my lord.
Para B?
My lord.
29, go to 20.
Gana Shikshak is required to pass OTT within 31st March 2019.
Correct.
If he has not passed OTT earlier, if he has not passed the OTT, my lord,
you should not ignore the speed breakers. There is a speed breaker in the sentence. Full stop is there.
No.
If you ignore the speed breaker, accident may happen. Is it not? Therefore, honor the symbols, comma, semicolon, full stop. You should honor them. Otherwise, I will not be able to understand. Already, I have difficulty in understanding you people. And you have difficulty in understanding me also is true. Such Gana Shiksha is required to pass OTET within 31st March 2019 if he has not passed OTET earlier. First time. Then, if she or he does not pass the OTET by such date, she will not be eligible to get any further increment after 31st March 2019. So, increment cannot be given, but regularization cannot be denied is your contention. How courts have you?
The Honorable High Court also has passed one
similar matter. With a paragraph kindly.
Also, any W also.
Say copy with your friend also. Brother, look into. He says, rule says he cannot earn increment. But on that ground, you cannot deny regularization is his contention. Because
my lord, also in W also it is also like.
But judge is in your favor. Kindly do not pollute that opinion.
My lord, sir, I'll go.
You will look into issue notice. Learned DG is requesting to accept notice for the respondents. All the private respondents. No private.
All that no private.
Respondents. First, since short point is involved. Mr. Monty, yes, can we dispose of this matter with direction to reconsider or
to go to whether there is any appeal or not, that is to be settled out.
That's you should take notice. Let me take supplements for the respondent. All the matter in the first week of December 2025. Take this.
Yes, my lord, 18 matters are there.
Along with the WP number service. What he says is, conditions for regularization are different. Conditions for earning the increment are different.
My lord,
one requirement cannot be read into the another is sufficient.
My lord,
these judgments are there. Just look into.
My lord,
there are judgments. Look into it.
My lord.
Then I will have it in the second week of August. 11th, 12th of August. 12th of August. Call is the top order. Yes.
Item 11.
11. Item number
11, my lord.
Yes, sister.
My lord, this is a claim difference in amount of area to be reduced scale of pay, my lord, as OP calculated or erroneously and discriminated treatment. Previously, in the WPC, your lordship order without payment paid without any discrimination, my lord.
Because madam means outstation advocate.
Yes.
Outstation advocate.
And copy is not served on us.
Copy is not served on you.
Fine.
Push this matter. If the petitioner furnishes once copy to the learned AG and not otherwise.
Item 13.
Yes, sister.
The second round litigation, my lord. My annexure 8 is challenge the rejection order.
Annexure 8. Annexure 8.
Yes,
page number. Why are you not? Why people advocates say do not mention the page number? Annexure page number. That's how the courts operate all over the country. Yes. Page 40.
Yes.
What does it say?
The lordship directed to dispose the representation of the petitioner.
They have rejected it.
Yes, my lord.
In representation, what you had sought for?
Well, I was eligible for the physical.
Career advancement scheme.
Yes, my lord.
You have been working since how many years?
I am retired, my lord.
Huh?
Retired teacher.
No, how many years? How long? Since when were you appointed? That CAS is 10 years, 20 years, 30 years without promotion. How many years of service you have put in?
I have already completed 30, my lord.
31 years. You have completed 31 years of service.
30 already completed. I am retired teacher, my lord.
Is it 30 or 13?
30.
30?
Yes, ma'am.
Yes, government advocate, just you are for respondent.
Yes, ma'am.
Your designation, sir?
AG, additional government.
AG. Learned, heard learned advocate Srimati so and so.
Parvati.
You are not advocate.
Yes, ma'am.
A case is made out for issuance of notice. First stop, issue notice. Full stop. Learned AG is requested to accept notice for respond. Any private respondents?
No, my lord.
No private respondents?
No.
Wife of the DIXIT employee has come up with.
Correct. Because what she says is my husband ought to have been granted the CAS benefit. There it is. Probably first week of September. Oh.
Item 14.
14.
My lord, the petitioner is president of Bhagirathi Sagar Suraksha Parishad, working for restoration of a pond. They
Is it a statutory body?
No, it's an NGO, a citizens group. And the administration, upon the demand, agreed to rejuvenate the pond.
Pond,
Pokari.
Reservoir.
Reservoir. And again, they dug up it and piled the silt at the bank of the pond.
After desilting.
Desilting. So we again went to the administration, and by annexure 2, page 10, administration agreed that they will remove the silt to a distant place and restore the area of the reservoir as it is. Annexure 2.
But this is in the nature of PIL.
Yes, exactly.
It's a matter of PIL, but my writ is under the consideration that it is Apex Clean Environment, Article 51. I am entitled, so I can file the return.
But that is not agreed with the apex court. They say this is a matter of PIL, if not breach. It's a matter of PIL. You file one more set. I direct the registry to place it before the Honorable Chief Justice. All right. The essential grievance of the petitioner partakes the one to fit into PIL jurisdiction. First. Next paragraph. In view of the above, registry to post this matter before the jurisdiction, before the original bench, earmarked for PIL, if second set is filed within 2 weeks.
Item 15. The issues relating to grant of legal aid certificate, madam. The fact of the case is that after the death of the adoptive parents, the petitioner applied for legal aid certificate, which was rejected, against which appeal was preferred. Appeal reminded that after due inquiry, the Tahsildar can grant the legal aid certificate.
Under which
miscellaneous certificate rules.
No, under which statute? Legal
that
aid
means
certificate.
miscellaneous certificate rules.
Okay. The rules are promulgated under which act?
That I have not examined.
Whether there is such a procedure, legal heirship certificates are
Yes, my lord. Under the miscellaneous certificate rules, my lord.
Rules.
Yes.
They are not given to you.
No, man. At the remand, legal aid certificate was issued by the Tahsildar. While the matter stood thus, some of the relations of my parents, adoptive parents, have filed another case before another Tahsildar.
Of another district, another taluk.
My lord.
What he said.
My lord, in that case, the Tahsildar granted legal aid certificate to one of the relation and dismissed, or two persons have filed two miscellaneous case, my lord.
One is dismissed.
One was allowed, another was dismissed. Against these two orders, appeal was preferred.
Against first order which allowed,
dismissed. Two appeals were filed, two appeals were dismissed, against which revision was filed before the collector. Divisional court what held that this is a disputed question of fact, it can be resolved in the civil court. My lord, after that order was passed, the order which the order by which the petitioner has got the legal aid certificate, that was never been challenged.
It has attained finality.
It attains finality. The Tahsildar what do after revision, he has cancelled my legal aid certificate.
In the revision filed by whether one of those parties. Within what period the revision? When you were granted certificate? When
Your Lordship will kindly see annexure.
No, I am asking a question. When the legal aid certificate was given to you and when revision was moved?
Legal aid certificate was given to me on 1/4/2025.
For 2025.
And revisional order was passed on 26/3/25.
It cannot be.
26/3.
1/4/2025 is your order.
24.
How can 24 it is?
My lord?
You say the legal heirship certificate has been accorded to you on 1/4/2025.
Yes.
If that is so, how can
25 it is wrongly
before the issuance?
It was granted to me 1/4/25.
1/4/25.
Yes.
And revision is.
The revisional order was passed on 26 March 25.
How can that be? Is our question.
That was filed by the relations, my lord.
No, very certificate was granted to you on 1/4/2025.
25, it was cancelled by the Tahsildar.
1/4/25 was cancelled.
Yes.
And then revision was filed on?
No, revision was filed by other relations.
Other relations had filed that. Take notice, let us examine.
Then private parties are there. Your Lordship may kindly see page 20, paragraph 70. The civil case is
Go to
pending.
civil court and have disputed questions are
Civil suit is pending before the appropriate court.
Suit is pending.
Yes.
Suit is also pending.
Yes.
Between?
Party, your Lordship may kindly.
Those relations, they have filed a civil suit.
But you are not a party to that.
Yes, I am a party to that. But your lordship will kindly see. Once a legal heir certificate was granted to me after following the due process of law, that was not been challenged.
Whether
that is not been challenged, and there is no interim order in the suit.
No, I'm asking you. What for these legal heirship certificates are granted actually? Is it a succession certificate?
No, legal heir certificate.
It is a legal heir certificate. That you are son and daughter of so and so.
It is required for service, for inheritance.
Ration card like this.
Pension, area pension.
Family pension, etc. Okay. What's the consideration?
Once my lord granted, that has not been challenged.
But
even if there is a suit was filed in 21. Your lordship, the legal heir certificate was granted in 25. During pendency of the suit, there is no interim order in the suit not to grant legal heir to anybody. Therefore, once that order has not been challenged, can the tahsildar review the order which was passed by the appellate authority in my favor?
Yes, brother. Madam's question has to be answered in the
Sub-rule 2 of Rule 5 of the miscellaneous rule says, Your Lordship, I am provided.
Anyway, you file for admission case is made out. I am not hearing now. Admission case is made out. Because if a higher authority issues the certificate, the lower authority cannot revoke it. Number one. Then secondly, the said certificate having attained finality, that cannot be meddled by another authority unless something is said in the suit itself.
No, we'll file
that issue emergent notice.
And there is a private party also. He
is requested to accept notice for. So is requested to accept notice for official respondent. Emergent notice to private parties. Any interim order yourself?
Stay operation of the order.
Impugned order shall stand stay till the next date of the first. This reprieve is granted on the submission of the counsel appearing for the petitioner that the heirship certificate in question has attained finality and therefore the revenue authorities could not have meddled with it, especially when there is no order by the court in which civil suit in OS number.
That is, my lord, civil suit number 256 of 22.
Pens on the court of
London Senior Civil Judge Jagatsinghpur.
Yes. Learned Senior Civil Judge
Jagatsinghpur.
Item 17. Item 16.
Item 16.
Item
15.
16.
1 5 or 1 6.
Oh, 15 में मुँह साले.
1 6.
He is disturbed today. 15 টা मुँह साली ब्रा.
15 नहीं तो 16 category.
17, 16, 15.
9, 17, 16 call libra. Item 16, 1 6.
1 6.
Wait, please.
Yes.
Well, the rate is.
He will give rise to one more dispute. As to 15 or 16.
But the rate has been filed challenging.
Mark your numbers in the correlation. It becomes easy for you. Yes.
My lord, the rate has been filed challenging the inaction of land official BDA, my lord.
Make use of the mic. See my voice, compare it to your voice. Voice should be high, decibel should be high. Otherwise, judges will not lend their ears at all.
My lord, the rate has been filed challenging the inaction of land official BDA, my lord. That is P4, my lord. Opposite for not providing the possession certificate of to the petitioner, my lord.
Naksha thereof.
Yes. My lord, kindly have a glance at annexure 1, page 11, my lord.
Page 11?
Yes, ma'am.
This in Orissa.
Oh, yes, my lord. There are.
What it says?
My lord, this is the certified copy of the ROR, my lord, record of right, which the land is recorded in the name of the father of the petitioner.
Father of the petitioner.
Yes.
Father is still alive?
No, my lord.
He's
dead. He's dead.
Now, after that father's death, you should be given certificate.
Yes, my lord. Now the father, after the father's death, the legal heirs of the late father are in possession, that is the petitioner and the OP 6 and 7 man, private parties. Now, the BD has the page 12, my lord. Kindly have a glance. It reads, my lord, the plot number 9162061. Kindly have a glance. Then 9162066, 9162063, 9482053. All these are 40% of ceiling area has been taken by BDA for development in that area, and this is the remaining area that is in English. But kindly have a glance at TPI. Kindly have a glance at TPI 1888, ceiling case number 1/76, moved to another khata, my lord. Another record of right that is named in the recorded in the name of BDA, man.
Why you are a court lawyer, disturb the court proceedings? You are not supposed to disturb the court proceedings, sir. See. Yes, brother?
Yes, ma'am. My lord, the land is recorded in the name of father and 40% ceiling area has been taken from the lands of the petitioner and OP 6 and 7 and has been
in respect of remaining part, you are in possession of the property.
Yes, my lord. I am in possession of the property.
Now, your representation seeking a possession certificate.
My lord, I have not filed any representation, but kindly have a glance at page 6, annexure 6, page 21, my lord. That is the
page 21.
Page 21.
Yes, what?
That is the letter by BD officials, my lord. Saying that these are your land.
Yeah.
This new land has been allotted to you. That is 1818, 2499, 2501, 2503.
Correct.
Kindly take possession of the land.
For taking possession, what is necessary now?
Now, what is necessary now, my lord, is I will go to the BDA officials and I will take possession certificate then and there. That's all. Simple process, my lord.
They have asked you to take the possession of the land.
Yes, my lord.
This was in 31/3/2016.
Yes, my lord.
And you have not taken possession.
I know, my lord. They are not giving possession. Now the dispute is, my lord, they are saying originally the land was recorded in plot numbers 916-2061, then 2053, then 2063, then 2066. It is what their record says, my lord. But in the revenue record, it is recorded as 916/2061, 916/2053, 916.
Let him take.
And my lord, that is
dispute in regard to entry itself.
Yes, ma'am. My lord,
their entries do not match with these entries.
My lord, that has been also clarified at annexure 8, page 23, my lord.
Let the emergent notice go.
Obliged.
Let them say. Then it becomes easy.
Obliged.
Issue emergent notice. Who are respondents?
My lord, the respondents are
Main grievance is against opposite party number 2. That is Bhubaneswar Development Authority.
No, my lord, 2, 3 requested to accept notice for first respondent government. Any panel council?
Panel council.
Yes, one panel.
Mr. Dayananda Mahapatra is regularly appointed.
That panel council, Sri Dayananda Mahapatra is requested to accept notice for
Like pioneer advance.
Mr. Pradhan's name may be recorded, my lord, because I can actually, we cannot take notice. Mr. Pradhan, panel council is requested to accept notice for respondents 2, 3, 4. Correct?
2, 3, 4.
2, 3, 4. You appear for 1, 5, 6. 5, 6.
Yes.
Emergent notice to private parties.
6, 7 and 8, my lord. Private.
7 is good. Returnable within 4 weeks. Last thing, I'm repeating that you add. Okay, in all matters, obviously.
Item 17.
Yes.
To comply the previous order, your lordship may place this matter on 7th. Because I am praying to comply the previous order. Let the matter be placed on 7th.
What is that?
Previous order, there is some amendment was necessary after arguing the.
You want to amend the
prior person. I am challenging the revision of pension as well as the order of recovery. the previous bench observed you should challenge the excess amount paid. That's the only amendment I have to do.
So that counsel is granted 2 more weeks.
No, 7th milliards, old person, on 7th.
On 7th it should be called.
On 7th it will be called because I have called them. One of the Chennai, one my teacher is there and one is
7th of August 2025. At the request of learned counsel appearing for the petitioner to effect
previous order.
To comply with the previous order.
Published.
Finally.
Item 18.
Yes.
Well, after the process of selection, the petitioner was appointed as a contractual peer in the opposite party number 2 college on 28/10/2021.
28?
18/10/2021.
2021?
Yes. Under annexure to page 8. While working as such, he joined on 1/11/2021 and while working as such, under annexure 4, page 10. All on a sudden, the principal made office order number dated 6/5/2024, like the term of following employees has been completed as per details mentioned below.
Yeah.
Without any reason.
Was without reason. It was a term engagement.
No, not term engagement.
Not term engagement. Very clear.
Annexure 2, the engagement order.
Was it a permanent appointment?
It is appointed a peon temporary contractual basis in existing vacancy. The existing vacancy with remuneration salary of 4,500 per month only. You are direct.
Your state minimum this notification is not applicable.
No,
only 4,500.
Minimum is applicable.
But how they are paying only 4,500? 150 rupees per day. Yeah, you are asked to quit now.
Millard?
You are asked to leave the job now.
No, by virtue of that order, I have been out from the job.
On 6th May 2024, the period is over.
There is a prescription of the period.
Yes. Your Lordship, I can see page annexure 4, page 10.
That case is grievance.
Yes.
It is wrongly said as prescribed period, but the appointment order does not say any prescription. Therefore, without notice, you could not have done easy strategy. Suppose where he should go? At least some reasonable time. Brother, next month you have to leave. Take advance salary and leave now. That also you can do. Issue emergent notice, the DG is requested to accept notice from any private party.
Yes, OP number 2.
Appear for response number 1, emergent notice to OP number 2, returnable 2 weeks.
Mobilizing.
Item 19.
Fairness.
Yes.
Let's see. It's was appointed as the rehabilitation assistance scheme on 2/5/18, let's see.
By 2018.
Yes, let's see.
Appointed as
clerk. Then, in the meantime, this Hon'Ble Court, Annexure 5, let's see. Annexure 5, at page 19, this Hon'Ble Court passed the order that there is no contractual post for the rehabilitation assistance scheme, as there is no such types of provisions under the 1990 rule. After that, I preferred before this Hon'Ble Court WPC number 1200/425 under Annexure 6, let's see. And this Hon'Ble Court directed to file the representation before the authority with citing the Biplab Kumar Mahanti case. I have made the representation.
Which like is again being reflected. Somebody laid it on this particular line. Come here, you will just see there no computer. I cannot see. Certificate in the applied medical practitioner leaves are made during the maternity leave.
The maternity leave. Different file here.
This is the value of right.
Maternity leave.
Going to be looked into.
No, here it is there.
Let your file so that if there is notice, then we can order. Yes.
She has paid for arrear maternity alone.
Maternity alone.
And a representation is pending.
Pending.
Sometime in February 25 or March 25.
You will consider it after the second pregnancy.
Yes.
He says
that can be disputed.
The short grievance of the petitioner is as to non-extension of maternity benefit in terms of representation that is stated to be pending at the hands of jurisdictional authority. Personal. Learned counsel for the petitioner argues that there is a constitutional mandate enacted in Article 350 which directs that the public authorities have to consider the representations in which the citizens hear their grievances and grant redressal thereto in accordance with law within a reasonable time. First off, next paragraph. Learned AG appearing for the respondent submits that if is it true? It is still pending.
No, see, they have said in Annexure 5 that 90 days will be allowed, whereas the Act is that 180 days should be allowed, 6 months. They have Annexure 5 Lordship, they have said that 90 days will be allowed, but my
another 90 days will not be.
180 days they should be.
That is what I am telling now.
Yes.
You don't understand English.
Annexure 9, Annexure 6 is there, the rule of Orissa that to all the added school also they will give the
180 days.
Yes.
The notice has to go. Because only 90 days you have given. Another 90 days you should have given. Have you seen the division judgment of ours about maternity benefit? Look, I don't remember its name. Just look into that. Issue emergent notice. The AG has requested of sub notice for the any private respondent?
No, Lordship.
Respondent. First one. Call this matter week of the next since a short point relating to availment of maternity entitlement to maternity benefit is involved. It will come after 2 weeks. You have to answer that. Just look into our judgment.
Item 20.
May I please?
Yes.
The petitioner was engaged as Sikhya Sahayak on 11/3/2015. 11/3/2015. He tendered resignation from his post on 3/8/2018 on account of his mother's illness. That is under Annexure 3. By addressing the resignation.
Resigned on?
3/8/2018.
Resigned.
He resigned.
Then offered a resignation.
Yes.
What is that?
He offered resignation on 3/8/2018, addressing that letter to the block education officer Pillai Body, who is not the appointing authority of the petitioner. Then, my lord, your lordship may kindly turn to Annexure 4 at page 13. Immediately after 1 month, she withdrew that resignation letter on 6/9/2018 by addressing a letter to the collector, who is the appointing authority of the petitioner. But till that date, resignation was not accepted. And my lord knows that before acceptance of resignation, one has a right to withdraw. And till today, my instruction is
not decided.
Has not yet been decided. He has made a representation to the collector under Annexure 5, who is the appointing authority. Let collector take a decision on that instruction.
Whether that has been accepted or not, that instruction.
She wants to withdraw. Even otherwise. There are judgments of the appellate which say, even after acceptance, the government as a model employer should reconsider the case for withdrawal of the resignation.
That part instruction I have
Let's look in. We'll call this next week?
Yes. Yes.
That AG has requested also notice for the respondents. First off, short point relating to right to withdraw the resignation before acceptance, is involved. Since short point relating to right to withdraw the resignation before acceptance is involved. First. All.
Yes, sir. My lord, the present petitioner's land is situated over the Kada Canal, my lord. They are personally affected, my lord, as because the branch water canal running through plot number 4430 and 4432 that has not yet been maintained by the government authorities, my lord. So in this
Channel is not maintained. What is not maintained?
Pardon, my lord.
No, you said something is not
The
maintained.
Kada Canal has been earthquake. I mean, Mati Podi that has been
Yeah, tell, no problem. I'll also learn.
Poti that has not been excavated by the government authorities, my lord.
Excavation has not happened.
It is also behind.
No, my lord, but we are personally affected.
There is not a person agree.
Where is your land?
My land is situated near the canal, my lord.
You take water from the same canal?
Yes, my lord. I have annexed the ROR copy, my lord. We are the recorded tenant and paying water tax, my lord.
Yes, sir. If his individual right is affected,
yes, my lord.
He cannot maintain a PIL.
27 page, your lordship, kindly I have paid the water rate.
His land is adjacent to that canal.
Correct. Therefore, from the canal, he takes some water.
My lord. For harvesting my crops.
One morsel of water for drinking also. But he will have a right.
Yes, for agriculture purpose.
Then he has got stronger right.
My lord.
You take notice and just come out.
May I pray one thing, ma'am? At the stage of admission, your lordship, may I kindly direct it to the collector to consider my grievance.
You will be happy with that. Will you be happy with that?
Yes, ma'am.
Annexer?
Annexer 3 series, my lord. Page 31.
Annexer 3 series.
My lord.
What you have prayed in that?
I have prayed to
translate in English and say.
To excavate the Kada Canal. The petitioners irrigate their agriculture and according to the number, I think, to the collector, my lord.
Petitioner, a farmer, having his land nearby the canal in question, is grieving before this court that because of non-excavation and desilting, the flow of water is affected and thereby right to use the canal is breached. Therefore, the counsel for the petitioner submits, intervention of this court is warranted. First. Next paragraph. Learned AGA appearing for the on request appearing for the respondents opposes the petition, contending that the right to use the canal is not specifically demonstrated, semicolon. Even otherwise, grievance of the kind can be ventilated within a PIL jurisdiction, and therefore this petition is not maintained. First, having stoutly so opposed, now he agrees to instruct the district collector. The district collector. Which respondent?
Bhadra.
Which respondent?
Two, my lord. Two.
Agrees to instruct the jurisdictional authority to look into the grievance of the petitioner as has been aired in the annexure 3 series.
Page 31.
3 series. And in the light of pleadings in the petition. If a reasonable time is granted and liberty to take up a decision is accorded. First, this is a happy thing to happen. First, next, in those circumstances, writ petition is disposed of, directing the second respondent to take a call on the representations of the petitioners, copies whereof collectively availed at the annexure 3 series in accordance with law and within a period of 3 months. First, in that connection, all contentions of the parties are kept up. Next paragraph. It is open to the second respondent to solicit any information or document from the side of the petitioner as are required for due consideration of the subject representations. However, in that guise, delay shall not be proved. First one. No costs. Now, no cost means at the next level of the litigation, costs will be imposed. Therefore, I write that way.
Item 22.
Yes, sir.
Here, my lord, the petitioner initially working as Ganashikshaka is claiming the benefit of regular teacher with effect from 2014 to 2020, my lord.
14 to 26 years.
20.
That's what. 6.
My lord, under annexure page.
Why can't you hear the judge?
My lord, there is a judgment, Dhananjay Charan De.
Be attentive to the court.
Sorry, my lord.
What?
6 year, after 6 year completion of 6 year, the petitioner entitled for regularization.
Under which instrument?
My lord, as per annexure 2, my lord.
Annexure 2.
Annexure 2.
Is the resolution?
My lord.
Read relevant part.
The government is after careful please to
4,000 per month.
My lord.
Have you made the representation?
Yes, my lord.
Where is that?
My lord. Annexure 5, my lord.
Annexure 5.
My lord.
Yes, sir. Take a call on that.
No. Your Lordship. Now he has prayed. She was initially appointed as Ganashika.
Correct.
By virtue of this Honorable Court's order, which Your Lordship may see, and Honorable Apex Court order, in case of Dhananjay Charan De's case, their services were regularized as Shiksha Sahayaka. And accordingly, by the Annexure 4, they were their services were regularized, and the pay during the period of Ganashika was notionally fixed. Now he wants that those periods should be, the government should pay as areas. That is the grievance.
That is it rejected?
No, not yet rejected. Yes,
then he gives a representation.
Yes.
Should you not take a decision?
Yes.
Should you not tell? No, you see, for XYZ reason, you are not entering.
Yes.
That you should do. You should be driven to the constitutional court. Only with such cases are pending up.
You also made this photo and directly.
The petitioner earlier a Ganashiksha, having been regularized into service as
Shiksha,
is grieving against non-consideration of his representation for payment of arrears of salary during the period between 2014 and 2020.
Yes.
First time. Next paragraph. Learned the AGA on request and accepted notice for the official respondent opposes the petition, saying that for the period in question, entitlement is only notional and therefore no benefit can be claimed in terms of government resolution dated 17/11/2011, a copy whereof awaits at Annexure 8. Annexure 2. First, having so contended, now he agrees with the suggestion of this court that the concerned authority has to take a decision on the representation of the petitioner at Annexure 5 in accordance with law and within a reasonable period. First, this is a fair stand. Next paragraph. In the above circumstances, petition is disposed of. First, time for compliance is 8 weeks. First of all contentions are kept open. Next paragraph. It is open to the official respondent, the jurisdictional respondent, to call for any information or document from the side of the petitioner as are required for due consideration of the subject representation. However, in that case, delay shall not be in this standard form. Now, no course.
Item 23.
8 weeks. 8 weeks, which would include communication of the decision taken to the petitioner. You have to inform him.
Yes.
Okay.
Item 23.
May I please, my lord?
Yes.
My lord, in this case, the annexure 3 is under challenge.
Annexure 8.
3.
My lord. What is that?
Well, this is a direction of the opposite parties, this is a decision rather, by which they have dissolved all the governing bodies of the aided educational institutions of the state. My lord, in this case, my lord, page 21, my lord, Annex 3. Notification number 5189.
So next.
Yeah. In exercise of the powers conferred under proviso to subsection 6 of section 7 of the Odisha Education Act 1969, pending reconstitution of the governing bodies or the managing committees, the government, after careful consideration, have been pleased to dissolve the governing bodies or managing committees of all non-government aided colleges of Odisha coming under the purview of Higher Education Department with immediate effect, except the autonomous colleges, the colleges established by minority communities.
That will not apply to you.
No. The second paragraph, whereas then they have fixed either the ADM, if the college is situated in district headquarters.
So the DC will act as the deputy district collector, will act as the committee.
Additional district collector. And in other colleges, the sub-collector.
That section, how that section reads?
The section of the
Section 7, subsection 6.
Mine. So that's what is my humble submission, that there is no provision which entitles them to dissolve the governing bodies of all the colleges this way.
Read the section they have quoted now.
My lord, it is at the education, Odisha Education Manual, the rule is subsection 6 of section 7. If your lordship is having the...
Please read. I will give attention to
the prescribed, my lord, the proviso they have quoted. Let me quote the rule and the proviso. The rule is, the prescribed authority may allow the governing body or the managing committee, as the case may be, whose term has expired under subsection 4 or subsection 2 of section 7A to continue in office till the governing body or the managing committee is reconstituted, or appoint any person or persons to exercise the powers and discharge the functions of the government. This is the rule. And the proviso says...
One second. What is meant by that now?
This
even after the elected tenure of the body is over, still government may permit its continuation, number one. Or it can appoint some officer to exercise the functions of such managing governing body, managing body, whatever it is. That is first part. Then go to...
No, that point is moderated by one more condition, that is 7A. 7A, whose terms have expired under 7A. 7A is a punitive clause, where if the governing body neglects in its action or has done something illegal, then that is to be superseded. 7A, the term of a governing body will expire by supersession if there is some anomaly noticed in their functioning.
No, that we only say.
That is what.
Two things. Governing body coming to an end by your eclipse of time. Eclipse of time is one thing. 3 years.
3 years.
3 years over, therefore government commission. Governing body's tenure is still in existence. But because of misconduct, it has been superseded. In these two circumstances, even superseded governing body also can be continued if government is of that opinion. That is the truth. And then go to second one.
The proviso is provided that the state government may reconstitute the governing body or the managing committee, as the case may be, notwithstanding that the term of such governing body or managing committee has not expired. Government may do it.
In other words, it can cut short the tenure of the elected government.
Elected governing body. On such reconstitution, the existing managing committee or governing body, as the case may be, shall stand dissolved.
Correct.
And the legal position is absolutely clear that governing body is a continuous body. That cannot be a vacuum. That's the first.
Governing body means elected body.
What elected, selected, there are two ways of doing it. Now, what the government has done, this is actually a game we play. All of us have played in this state, youngsters. That's called basket, where we pile on cigarette or matchstick boxes and we break that pile with a ball, and we try to reassemble it. And before we reassemble, if the ball strikes us, then the game is over. It is a game of basket between the government and this honorable court, your lordship.
On what ground they have done this?
That's what I'm saying. This is the ground they have done it. This is the ground they have shown. There is no absolutely valid ground. They should have, that's what I was proposing, that the rule says that there should be a governing body duly constituted. What the government does, it periodically just dissolves those governing bodies. And this honorable court keeps on pressurizing them that you reconstitute the governing body, So since they cannot defy the orders of this court, they reconstitute few governing bodies. Then after that, after a period of time, they again bring in an order whereby they dissolve all the governing bodies. So they manage the governing body, the colleges, through the sub-collector or the ADM as the case may be. They do not allow the colleges to be managed by governing bodies. That is what has happened, my lord, in the year 2020.
No, there is no gap between two sentences.
No.
In your speech,
My lord.
there is no pause.
My lord.
But unless there is a pause, I cannot understand.
Sorry, my lord.
So after one sentence, you have to stop.
My lord.
You have to assess how I am responding to your statement. Then go to the next statement.
My lord, absolutely. So the point is, they keep on dissolving the governing bodies, do not allow the constituted governing bodies to function. And periodically, they just dissolve the governing bodies. And this honorable court, in many occasions, tell them that you reconstitute the governing body.
You said that.
Yeah, right. So that is what has happened. In this case also, by this order,
How many governing bodies are dissolved by this way?
My lord, there are 1,439 colleges in this state. And according to this order, only those governing bodies which are of the autonomous colleges, which
in a wholesale way?
Yes, ma'am. All the governing bodies.
What is the ground, brother? You have power, it's true. Power is one thing, its exercise is another. I have power to hang anybody, therefore I will hang him, is no ground. You should have power to do, but you should have facts which warrant invocation of the power. So existence of power is one thing, its exercise is another. That's what his submission. And the text of the section which your friend has now read, it does not authorize dissolution of all the governing bodies in a wholesale way. On individual basis, you have to do. There may be good governing body, there may be bad governing body, it may be a moderate governing body, there may be a best governing body either. So individual cases you should treat. How can you make a wholesale order like this? All governing bodies of all unaided educational institutions stand dissolved, like Napoleon Bonaparte. How can that be done?
I have to obtain instruction.
Yeah, when it is issued?
My lord, on 23rd December 2024.
Okay. When did you file the petition?
My lord, I just recently, because they gave the time to reconstitute within 3 years.
Otherwise, if it were to be in time, within 1 week or so, I would have granted interim order to you. Issue emergent notice. Learned AGA is requested to accept notice for the official respondent. Any private respondent?
No, my lord.
No private respondent. When will you file objections? This is a serious matter. Right to administer and run educational institution is also very important right, though not a fundamental right.
You actually granted 4 weeks time.
4 weeks?
Yes.
May I pray, my lord? May I pray, my lord? Our governing body, our college has a constituted governing body. And as per the rule, that has to continue. Till that time, if an injunction is put on this Annex 3.
But it's of, I would have agreed with you. Because of the lapse of time, this is about more than 7 months ago.
Because they had given 3 months, so we were waiting because
8 months ago. Therefore, otherwise I would have granted. You argued very well. I appreciate that contention. There are such judgments.
Yes, I have
judgments. Many high courts have held that. Okay.
Item 24.
If you are not posted after 4 weeks, move a memo and remind me 1 or 2 sentences of today's argument.
My lord.
And I'll get it posted.
May I please your lordship? My lord, this is a similar case covered by Osuk Mahapatra, which has been your lordship posted to Monday, my lord. Similar matter.
Tomorrow?
Yes, my lord.
Monday.
Last item.
Issue. Yes. Learned AGA is requested to accept notice for which respondent? All respondents.
My lord. Similar matter posted to
This matter along with WP number. Give the number.
Last,
I do not
yesterday item 21, my lord. Yesterday item 21, my lord.
You should write down number and tell this. Obligatory sitting and talking in the court. Instead of that, you can apply mind to what I should argue, how judge is responding, what best I can make him to understand. These efforts you do not do, just spending, discussing. Leaving the court when court is talking. Yes.
Item 25. Your Lordship. My Lord, petitioner is a retired headmaster of primary school. My Lord.
Headmaster.
My Lord.
Makes use of the why mics are not working in our phone. Go to do something to the mic. Your voice should be audible to the last ventures also.
My Lord. My Lord, the petitioner is a retired. Annexure 6, my Lord, page 8 in my challenges. The order of
go to prayer column.
My Lord.
Prayer column.
Prayer, my Lord. The prayer for deduction of the amount deducted, disbursement of the amount deducted from the gratuity, my Lord. That is 64,834 after retirement, my Lord.
When you retired?
Retired, that is Annexure 6.
Ask the I'm
36, 2024.
Retired super 13/6, 2024.
Yes, Mr. Monty. Rafiq Masi appears to be there.
In fact, here, this is an overpayment. Exactly. He was promoted to the post. Initially was Shiksha Karmi, subsequently promoted to 21 and retired in 24. Admittedly, it was a overpayment. For that, Annexure 6 was issued. It is amounting to rupees 64,834. However, I will file a response to that effect. It will be clarify the situation.
Yes, Mr. Monty is requested to accept. Did he admit that it is excess payment? You said admittedly. You used the word admittedly in your submission.
Because in the process it is overpayment. But that after it.
I am not on that. Admittedly by whom? Who admitted?
No, it is the respondent, the opposite party was paid in excess for a wrong treatment.
Admitted means he should admit.
No.
It is mentioned in the Annexure 6, my Lord. Nothing is mentioned. Annexure 6.
Yes, it is excess payment where it's a public money where he cannot retain.
No excess payment. No, within the period of my service, entire service, there was 2 increments only. After there is a pay fixation also. After the pay fixation, that is pay fixation is Annexure 4. Annexure 4, page 15. After that, the petitioner was promoted to the headmaster and availed 1 increment. The non-official, the petitioner came to the office and found that there is 1 increment extra. That should not be. But there is no mention in any paper or any intimation to the petitioner.
Granted 1 increment.
Yes, 2 increments.
Taken 2 increments.
Increments within the entire period. I am appointed in 92 and retired in 224.
You became headmaster when?
My Lord.
When did you become headmaster?
Headmaster, that is Annexure
2023.
That is Annexure 5, my Lord.
Annexure 5 at page 16.
Tell the date.
14/7/223. 2023. Annexure 5, my Lord.
14/7/23. When the increments fall due in your state. In Karnataka, they fall due on 1/4. In your state, when the increments accrue to all the employees?
Same.
1/4.
Different.
Then one increment he is entitled to.
For that, I will give the response.
Issue emergent notice. Mr. Mohan Taylor, the DG accepts notice for the respondents. First, in short, point is involved of this matter in the first week of September.
Published.
Take this.
26.
No, I put 26 and then Mr. Naik will tell you pass over.
Pass over. Pass.
Item 27.
May I please, Your Lordship?
27.
May I please, Your Lordship? This is a glaring case where Your Lordship will find how a subordinate officer is being harassed by a higher authority, my lord. Time and again, my lord, the petitioner here was working as the in-charge headmaster of a government high school, my lord. My lord, he met with an accident, road accident. So, my lord, he sustained fracture injuries. So immediately he was taken from the spot to Visakhapatnam for treatment, my lord. My lord, because he was admitted to the hospital at Visakhapatnam and he was having, my lord, underwent operations, my lord, he could not submit the leave application, my lord. Subsequently, when he came back from the hospital, he submitted the application, my lord, leave application. Yes. And surprisingly, the block education officer, without a DP, without initiating any DP, my lord, imposed punishment on him, my lord. Your lordship, punishment of censure and treating the period of leave as extraordinary leave, my lord. Your lordship may kindly turn to page 28.
Censure is for what?
That he will not repeat such type of mistake in future.
What mistake? He was
my lord, because he said that why have you unauthorizedly you have remained on leave, my lord. That was the reason for which, my lord, an order under Annexure 8, page 28 has been passed without initiating any DP. Order has been passed, my lord.
28?
Page 28, Annexure 8. It is on 30th of October 2023, my lord.
Warned not to repeat such type of practice in future.
Yes.
What is this, brother?
And this is the period of absence, that is from so-and-so date to so-and-so date, is treated as extraordinary leave. EOL.
Then what?
So I challenge this order before this honorable court in the writ application. My lord, your lordship may kindly turn to next page.
What happened? Just tell, I believe you.
In that writ application, notices were issued.
Notices are issued.
Yes.
Still pending.
Yes, my lord, that is still pending, my lord.
Then what?
Now, after receiving the notice, he started harassing him, my lord. Your lordship will find now what he has done. He has, my lord, although for the month of February 2025, I have worked throughout the month, my lord. Your lordship may kindly turn to page 32. He has shown, my lord, 0 working days against me, my lord.
He has shown you as absently.
Absent 0 working days, although your lordship may kindly turn to next page 33.
33.
Yes, serial number 1. I have worked for the whole month. 1, 2,
You are a
2025.
teacher. You are a headmaster.
Headmaster, in charge headmaster of that school, my lord. Now he has.
1 second.
Yes.
Yeah. You are taking classes also.
Yes. I was taking classes. I have attended there is the.
Now what he has done?
My lord, for this month he has not paid the salary to me. And then, my lord, your lordship will find, my lord. Under Annexure 15, he has transferred me to another upgraded high school where I was posted as a junior. Page 38.
You have reported for duty.
I have reported for duty after this transfer, but for the month of February, unnecessarily my salary has been blocked.
This is a very substantive. At page 36, Annexure 4, of course it is in Odia. Only for the month of February, the salary has not been paid.
No, not only that. We can understand that you do not pay salary. But you have shown him as absent when he was very much working in the school. Number 1. Kindly see the conduct of this that officer. He met with an accident. He was admitted to hospital. Therefore, he remained absent. Can it be said to hereafter you are warned not to repeat? Did he drive the vehicle? Accidents do happen.
Yes.
If they happened, even presidents of India, presidents of America's vehicles also have met with accident. How can you warn him for that? He is not the driver. He did not invite saying that please take your vehicle on me. appears to be something mad with that fellow.
This
Take notice.
the representation is also pending with the authority.
No, that I would have said consider the representation, but I don't have faith in such officer. See
file
what
the
he
responsibility.
has done. But apparently,
Yes.
we do not know the truth because this is one version. Only after you file the objections, we will know. But apparently, he did not have fair treatment at the hands of that office.
But so far the prayer portion is concerned, it is only confined to the salary for the month of February.
At least because he thinks that very able government advocates will defend the case. At least to some extent, we shall make it courtship.
And the next I will have to file a separate application because in one application I cannot make two prayers.
If you take notice now, warn that officer. Just ascertain the fact. Don't go by his version. You ascertain the facts. I warn him that if his allegations are true, he will have tough time in this court.
Yes.
I will ask him to be personally present before the court. I will make him stand in front of everybody so that all people should see him with red eyes. If it is true, I do not know. If it is true, appears to be. He has worked it. He has produced the attendance register. And the officer has the audacity and duplicity of saying that he has not worked at all. And then how the teachers should work? They will be under the mercy of those headmasters, those higher officers. But they cannot engage themselves in good education at all. Issue emergent notice. Mr. Mohanty is expected to accept notice the official respondent. All respondent.
1 to 4.
1 to 4. Call this matter day after tomorrow.
No, my lord, it's Gajapati Rayagada. It is the longest route.
Call this matter. Choose it.
At least 3 weeks or 2 weeks. May require.
You have to take instruction.
Even by road roller, we can reach it within 2 days. 2 weeks. 2 weeks. Call on. You fix it.
14. Item 28.
28, please, your lordship.
Yes, sir.
This is relating to transfer.
Yesterday,
exactly.
I said it in a jocular way that you are seeing your junior is saying that Varadarav and you are not good. Yes, no.
That is
so. Therefore, take it as a humor.
No, I take it as a humor. I've been here for last 35 years. I'm always, my lord, that way. That doesn't hurt me that.
My lord, exactly that similar matter of the similar education district also.
In fact, same transfer order, 2 persons have filed 2 writ petition. Yesterday, your lordship had the occasion to deal with
it. Can print in this.
That's the only thing, that only deviation I would like to pray for your lordship is.
In that matter, I remember you had made that application to the district officer. When you should have made it to
director. Your lordship, please to observe that. Khali Kshetra, in that case, your lordship said 3 days to file the appeal. Even today, the order has not been uploaded. I'll only humbly pray. That may be made 7 days.
1 week within.
7 days it will be convenient for.
In the other case also.
Serial number?
That was serial number 27. WPC 20204 of 2025.
The subject matter of this petition is substantially similar to the one in WP number so and so between so and so, disposed of by this court yesterday, granting reprieve to the litigant therein, argues learned senior advocate appearing for the petition. And therefore, he further submits that similar reprieve needs to be extended without discriminating the petitioner hearing. First one. Next paragraph. Learned Mr. Mohanty, having turned the pages of the petition papers, opposes the petition contending that similar matters are piling up before this court unnecessarily when parties can approach the jurisdictional authority and have redressal at their hands. First of all. Next paragraph. having heard the learned counsel for the parties and having perused the petition papers, this court is of the considered opinion that the submission of the senior advocate Mr. Mishra appearing for the petitioner is independent, and therefore the relief accorded to the litigant in the coordinate case has to be extended to his client as well on the principle of bail. First, in the above circumstances, this petition is disposed of, granting same relief as has been accorded to the litigant in the coordinate case, subject to one variation, that the petitioner shall be may appeal to the director of elementary education within a period of 7 weeks. Reckoned from this day. First of all contentions are kept open. Till for facilitating filing of the appeal, the impugned order is kept in abeyance. If already not impugned.
That is the observation in the other. Yesterday's so grateful, man. In the other case, will the Lordship be kind enough to make it 7 days also?
But it appears I have signed the order.
That has not been uploaded, means your Lordship might not have signed. I'm not sure.
If it is though, make it 5 days. That's another coordinate judgment. Send words. Call somebody from the chamber. Ask him if it is not uploaded. Don't tell them not to upload. Yes. Okay. So great.
Item 29.
Here also I pray for ordained copy because I have to file the appeal. This 28, which your Lordship disposed.
Same.
No, the urgent copy I'm asking for.
Online copy to be acted upon. Okay. Yes.
Right, Regulars. This is also a transfer, not transfer, but deployment of a teacher. 3 days to another school and 3 days in his
current teacher in 2 schools.
Two schools. It is for administrative interest. So Lordship may kindly.
What is the distance between 2 schools?
45 kilometers.
45 kilometers.
He is a heart patient.
Oh.
His arrangement was done. The Lordship may have a glance.
So that heart ailment, what is the heart ailment? You said heart patients.
Heart patient.
What is that ailment?
Cardiac problem.
They are main, if you read any.
I have given all the prescriptions also. Page 15 onwards is the prescription. So all prescription.
No, what is the disease?
Disease is what I know is saying that he has some heart problem.
He has heart and therefore he has some problem issue. What is that problem? Does it come in the way of the job?
No, I am not seeking that. My humble question is that page 11 annexure 2 is the deployment order. Your Lordship just have a glance. Page 11 annexure 2. It says, in the interest of administration, the following arrangement is made in order to manage the day-to-day teaching and learning process of the school as mentioned below. I am in the second.
Om Prakash.
I have to go first 3 days to Chintamani Government High School, and the teacher Sushantan Kumar Naik, he is to come first 3 days to my school. And next 3 days, I will come back to my school.
This is alternatively. He will go to that school, he will come to this school.
For 3 days only, in a week.
What are the subjects you are teaching?
PET.
They are all PET teachers.
Wait,
PET teacher. It is an internal arrangement and redeployment. And only for a particular period, till alternative arrangement is being made because absence of the teacher. This interim arrangement has been made as it appears.
Don't pollute your case by over argument. See, there are 2 schools.
Yes.
There are 2 PE teachers. Why same PE teacher cannot run the same school? Why one should come from this school and this man should go to other school? What is this jantar mantar?
Day after tomorrow, you just ask him to tell from which place it has to come.
This is around
Protect only.
50 kilometers.
The order is passed by district education officer Cuttack. His office is in Cuttack.
We can understand. If there is no teacher at all.
This is an interim adjustment.
That may happen. But not.
I will take instruction. Day after tomorrow.
Learned AG, Mr. Mohanty, accepts notice from the official respondents. Since a short grievance is made out, which can be addressed in minutes, push this matter a day after, as suggested by Mr. Mohanty himself.
Item 30.
Item 30. Yes, he retired approved teacher. This is similar, seeking a direction for pension. My lord was pleased to similar matter posting in some other delegated from.
Already 4-8 for them. 4-8. Issue emergent notice. Mr. Mohanty requested to accept notice for the respondents for this matter on 4-8. Any WP number is any? Do you remember? Other similar matters also.
Item 31.
May I please, Your Lordship?
Yes.
My lord, the annexures are in Odia, but the grievance of the petitioners are very limited. The petitioner is the owner of plot number 253 and the record of right published in their name under annexure 1. The adjacent plot bearing plot number 250.
What is your
my grievance is now the opposite parties are coming up for certain construction blocking the road of the present petitioner, and the present petitioner approached the executive officer of the municipality, who is authorized and empowered to redress the grievance of the present petitioner according to municipal law manner.
But he is not addressing.
Not yet addressing. Annexure 3 is pending.
Annexure, which is your
Annexure 3 is series is pending. Before opposite party number.
Just read Annexure 3.
My lord,
we'll try to understand.
My lord, Annexure 3, my lord, page 17. They have first narrated their address and they stated
addressing to the executive officer of the concerned municipality.
Opposite party number.
For redressal of their grievances, which is pending since 1905. And the sum and substance is because of the passage for the ingress and egress to the plot.
To his land.
Yes.
To his land, you know. So that may be considered upon.
Petitioner is grieving before the Real Court against non-consideration of his representation, a copy whereof awaits at Annexure A3, wherein he has raised some grievance relating to the difficulty of ingress and egress to his land because of alleged activities of a particular private party. You are not made him a party.
Yes, OP number 4.
Opposite party number 4.
OP number 2. First of all. Learned counsel for the petitioner submits that in view of constitutional mandate under Article 350, the subject representation ought to now be considered in accordance with law, and that having not happened, this court should come to the aid of petitioner. First, in the Constitution. Next paragraph. Learned AGA, Mr. Mohanty, on request appearing for the official respondent, opposes the petition, contending that some reasonable time has to be granted to the officers to act upon, since this is not the only job, they having many at their hands, and therefore petitioner ought to have waited without hastening. First, having so contended, now he fairly agrees to instruct the OP number 3 to look into the grievance of the petitioner as aired in Annexure 3
series
3 within a reasonable time, keeping open all contentions of the parties. First, this is a fair stand. Next paragraph. In view of the above, writ petition is disposed of, fixing a period of 8 weeks for passing orders on Annexure A3 representation in accordance with law. and also to report result of such consideration to the petitioner. First, next paragraph. It is open to same copy. Here. Right? No costs. Next.
My lord, may I say, if at all private parties are there,
notice
if at all extending the opportunity of hearing to both the parties, it will suffice.
It hardly before that. It hardly be noted that since we have this court has not issued notice to respond number 2, you're right, respond number 2, the hearing of the subject representation should take place after a notice to the said respondent at the hands of the OP number 3.
OP number 3 will notice to opposite party number 4.
Decision has to be taken by OP number 3.
OP number 3.
Notice should be issued to the OP number 4.
That is OP private part, OP number. You are right. You have to point out when we hear.
It will come to an end. Otherwise, 1 second they have to travel.
No, without hearing me, this has happened. Yes.
32, my lord. This matter is covered by Ashok Kumar Mahapatra. Your lordship fixed this case.
So it has been sent on Monday.
Issue on that date it is. Mr. The allotted AG accepts notice on the question. Partly official respondents call this matter on Monday when similar matters are stated to be pushed into.
33. Date is Russian.
Yes, brother.
The petitioner, pursuant to Annexure 1, he has applied for the post of Hindi teacher.
Hindi teacher?
My lords, in government secondary school. The process of selection was that the 100% of the vacancy shall be filled up by the concerned DEO. Now subsequent
by DEO.
District Education of DEO. Now he has made the application, your lordship. The vacancy position was that in the district of Khurda, page 54, your lordship may kindly peruse.
Page 54.
My lords. Serial number 19, Khurda. For the post of Hindi teacher, the last column is a Hindi teacher is there. Subject.
Hindi teacher.
Yes, your lordship. 26 vacancies were advertised, out of which 13 were reserved for UR and remaining 3 for SCBC.
Yes.
The petitioner is the SCBC candidate. He made his application under that category. Now, at that juncture, when his name was not found in the merit list, he approved this honorable court.
Earlier?
Yes, your lordship. Now, at page number 59, you will see that it is the final merit list for the post of Hindi teacher in the district of Khurda. Page 59.
16 persons.
Yes, your lordship, out of 26.
Your name does not appear.
No, your lordship. And moreover, most interestingly, when 3 posts were reserved for SCBC, I became SCBC candidate. None of the candidates belong to SCBC posts have been filled up.
They are kept vacant.
Are kept vacant. Now, at that juncture, this honorable court directed that when they have not considered the candidates against the SCBC category, they should approach the authority first. They will take a decision, which is impugned the benefit application. The annexure 12, your lordship. Annexure 11, page 66, which is impugned.
What is this?
They rejected my grievance on the ground that the validity of selected for a period of 1 year, which is over.
No, they have given the reason at paragraph 3.
My lords, may I just peruse that? What is the reason?
He says your client has secured 202.3634 mark.
My lords.
The other one has, the other SCBC category candidate has secured 203.441.
Master, can you again please say page 59? At page 59, every SCBC candidate, they were appointed against the UR vacancy, but not the SCBC category, your lordship.
They are unreserved category.
Yes, your lordship. Can you see page 59?
What is the cutoff marks for the SCBC?
There was none.
No cutoff.
Yes, because all the SCBC candidates were appointed against UR vacancies. SCBC posts were remained vacant. Page 59, just kindly see all the SCBC, category in merit list, you are.
Issue notice. That the DGMOT is requested to accept notice for the respondent. Which respondents?
All your
Respondents. Calling first week of September 2024.
Great.
What apex code in Indrasani? Suppose if the SCBC candidate secures more marks than the general candidate, then it goes to general candidate.
Yes, Your Lordship.
But this post will remain unfilled.
Unfilled.
So that filling has to take place.
But SCBC category candidates. Great.
Item 34.
Right, from 34, my lord. This is second round litigation. This is regarding regularization of my service and for grant of pension, my lord. The grant of pension, regularization service and grant of pension, my lord. What has happened, my lord? The petitioner, after serving for more than 25 years, your lordship kindly see Annexure 8, page 33.
Page 33.
Annexure 8, my lord.
Prasanna Kumar.
My lord. Sri Prasant Kumar Bhuya allowed to work as ad hoc peon with effect from 2/11/1998 by the Director Office Order number so and so is hereby repealed with immediate effect, that is 31st October 2024 afternoon. The official works assigned to Sri Prasant Kumar Bhuya is hereby withdrawn.
So after 24 years it is written.
Well, after he is withdrawn and he is allowed
No,
to.
I'm asking a question. You are not answering.
Well,
How many years of service he has put in?
more than 25 years. At the time of verge of retirement, the director issued this notice, my lord. That order is repealed. And
Repealed. You think that he is the legislature? See the word he uses. Or English is bad. Repeal is a word which legislature can exercise. 24 years he has worked.
More than 20 years.
More than 24 years.
Since 98.
Service was opened.
98.
It was deducted, everything was done, my lord.
Issue emergent notice. Call this matter after 2 weeks. Since a person who has relentlessly worked for more than 25 years has been sent home unceremoniously without terminal benefits. In the meanwhile, it is open to the respondents to file their objections. If any filing which no right to, the right shall stand forfeited. We can't treat the pensioners that way.
Item 35.
Lordships, but the petitioner has filed this writ application assailing the order of the dismissal passed by the collector on 15/20/2011, as well as the order of the appellate Annexure 6 that is 24/8/2012. Despite the fact that the petitioner has already been exempted from the criminal charges.
2012.
19/5/2012, na?
Yes, ma'am. 28/4/2012, ma'am.
Order number 2.
Yes, ma'am.
That is 17/5/2012.
Yes, ma'am.
You say 28/5. Which is that order?
That is the last Annexure 7.
Sir, 7 page 46.
Annexure 7, ma'am. That is the order of the appellate authority. Was confirmed the order of the dismissal authority, ma'am. That my acquittal from the charges was not for that. I am not entitled for that service. But the case is like this.
You were charge sheeted in a criminal case.
Yes, Lord. That I have subsequently exonerated from the by the.
Well, you may be, but you were removed from service.
Yes, Lord.
After holding the disciplinary proceeding.
Yes. But basing on the report of the no proceeding has been, but basing on the report of the committee, the collector dismissed from service without affording the opportunity hearing or formalities. However, after basing on that, but a criminal case was initiated against
you
me.
were acquitted.
That I have fully acquitted. That is
acquitted.
But Annexure.
There is word honorably acquitted.
But the honorable acquitted, that is not.
That's not there.
But the acquitted. Rashmi said that, but because in absence of any evidence against me, I have been acquitted.
So when the criminal case closed, so I am entitled to all benefits, my lord. That is why.
They were sent home because of the criminal case.
Yeah, because yes, my lord.
Where is that order?
Yes, that is Annexure 2, that is the dismissal order, Annexure 2. Yes, starts from page 19.
What was the offense alleged?
Offense that I was conducting that the misbehaved the girl child when I was staying with them at board by the ashram school.
Was it spoken?
That Poksho, that offense is 376, not Poksho, but 376 is the answer. Annexure 3 is the affair. 376, I feel. But that was found.
That's all right.
Yes,
the person who faces a charge sheet.
Yes, bro.
Because you have not been discharged. Trial has taken place. For want of evidence, you have been acquitted.
Yes.
But that will not be sufficient to send you to the school. What about the other children?
No, but that was the false allegation. That was completely false allegation. But if the evidence cannot support the prosecution, so ultimately I am exonerated but the lodgment of the allegation. But that too, but the proceeding was not initiated against me. Based on the report of the committee, I was dismissed. So dismissal is completely improper. No charges framed, no inquiries properly conducted in my presence, no matter, nothing but. And this is simple on the basing on the report of the committee, I was dismissed. And that too in the criminal case, everything has been taken care of. That is the
criminal case stands on a different.
Yes, so the procedure.
The inquiry has been conducted.
But what type of no charge has been framed, no opportunity has been given, nothing has been followed. Straight I have been dismissed. That I unbecoming attitude towards the girl child, I have been dismissed. So that was not the proper way for taking the action against me, my lord.
When you come to page 19?
Page 19, yes.
Office order, read it.
Para 2,
Para 1.
Para 1. Whereas on receipt of serious allegations against the Mohammed Nath Sri Sai, head sevak, Barayapani Sevasram, a preliminary inquiry have been conducted by the PA-ITDA Karanjia on 13/1/2011, which is prima facie vindicating the allegation, and thereafter a fact-finding joint inquiry has been conducted.
Joint inquiry.
Yes, joint inquiry. Yes, joint inquiry.
Please read.
Yes, joint conduct through I Sri Tara Swansho. But joint inquiry is made. Within that remained with them, but no opportunity has been given to me to participate. Whatever allegation, whether I have been involved in that criminal case or not, nothing has been done. Straight on the basis of that report, I was not dismissed from service. A termination is a major punishment. That is to follow how the man should be terminated. Due procedure of lawsuits ought to have been followed. That is section 15, rule 15, section 15.
Taking drinks.
Yes, that allegation. Many, yes, that's many allegations there. I put that they offered drinks to the girl child.
Not offered. You forced them to take drinks. And you put drinks on their head.
Yes, that is their allegation. These are our allegations. But whether I have done that, if any opportunity given to me that to prove that I have offered that, I was staying since from. And that too in the criminal case, based on that the criminal case, that the entire allegation has been based on the criminal case. That criminal case can be acquitted. So that is that is the blood fact. But is it the procedure how to take a major punishment of a dismissal?
All these allegations are true.
Yes, allegations. Many. Because I have gone
through Nobel Prize.
Yes, sir. No, sir. But the allegation there are many allegations which is really such type of allegation. Man should not. But whether that is the sustainable in my me that should be. And that is the criminal case.
Do you send your daughters and nieces to such a school?
That's true. But,
you will not.
No, I know that.
The parents also will.
But I will equally That is the basic on this. If the allegation is true, that certainly is not permissible. But whether my client has done, that is the important part.
So some inquiry has been conducted.
Yes, some inquiry is committed. That is the major point.
Maybe in every case you can't say that you should be heard in the matter. There are under Article 311, there is 311(2). The power is given to the president and governor.
That's true.
Difference in the
I don't dispute that.
for reasons to be raised.
I don't dispute that, sir. I don't dispute. But whether this type of the punishment has been given to with major punishment.
Major punishment of what?
The termination.
What punishment should be given to such people? Before they hang it to the nearest tree. But law does not provide for that.
Before that, the opportunity here should be given to my client and the procedures that Rule 15.
Whether any decision was taken under 311(2) to dispense with the
that has been taken care of while the order has been passed, which is impugned in this order. Apart from that, so for the impugned order under Annexure 7, my lord has hinting out this point, which has been well taken care of. And moreover, it is a order of impugned order of 2012, way back in the year 30.
Acquittal happened with it.
Yes,
acquittal.
Acquittal happened.
Yes, I have been acquitted. That is 2/12/2011.
That also 2011.
11.
But
Around
all these years, very
13 years back.
Schools are what?
And this is a ashram school. Most of them belongs to SC/ST communities.
And at 72 years old.
It does not depend upon SC/ST, etc. Any lady.
Ashram school.
And the allegations, I should not read it. It is that.
I read only a few lines.
that is I should not reiterate it.
That's true. I don't.
No, brother. Where is the decision taken under 311(2)? Not to hold it, dispense with the inquiry.
Page 26 for me.
What 26?
Starts from exhaustive order page, starting from page 19, relevant is page 26.
This is the order of collector.
This is the order of the collector from district magistrate.
This order you have not challenged.
This has not been challenged, my lord. It is a order of
Dispensing with inquiry. No inquiry shall be held with your participation. But in-house inquiry has been held.
Yes.
Preliminary inquiry has been held. Regular inquiry has been held. But your participation is kept out.
Yes.
For obvious reasons. But children may not come and depose at all if you are to be called there, if you want to cross-examine them. No case is made.
But
what is the explanation for delay of 14 years?
the acquittal was when was 2011.
Acquittal happened in 2011 only.
Yes.
But then where were you?
But the appellate authority decision I was waiting. The appellate authority decision answer 6 and 7. The appellate authority before whom I will appeal. That was the last order, Lord.
When it
yes, but that's annexure 7, Lord. Page 46. Page 46, Lord. Page 46.
That was 2012.
12, yes.
After only 13 years are over now.
Now my client is age around 72 years.
He will be 90 to
Yes,
20 years.
Yes.
But how can we stop the aging? Can the court stop the aging? Nobody shall. They will be all remain youth like nothing. It's not possible. We don't have such power. Dismissed on the following.
For that, I have got a judgment of this honorable court, the same division means, Lord.
Yeah.
Where if so one copy is clean, that but after acquittal, I am entitled to all benefits. After acquittal.
Suppose if you are acquitted when Babur had come to India in 1526, and if you come to DIXIT court today, whether I should grant relief, what your friends will feel about me?
But after acquittal, that is their duty to give me all benefits. But I had not approached the authority for time and again from that place.
No. Mr. Samaraditya Pal, in his public law relating to public service rights, where an employee is removed from service because of the criminal case.
Yes.
And he gains acquittal in the criminal case, he should be reinstated in service.
Yes. That didn't do that.
First proposition.
Yes.
Exceptions are these. Where an employee is facing the criminal case, and simultaneously the disciplinary proceedings are held and he is dismissed, the result of criminal case is irrelevant. Right. Because even the honorable acquittal will not come to your aid, because the dismissal has happened.
Yes.
Long before the acquittal happened. Yes, holding of disciplinary inquiry is one thing.
Yes.
Conducting of a criminal trial is another. From law versus story.
Yes, that have taken care of this. That have taken care of this judgment. This judgment.
Taking care of your submission.
Lashman can't see this judgment. That is a division bench judgment. That has been taken care of after acquittal. How the Ramlar's case has been that is only the magic term, but that is the that is exact. But that is the honorable acquittal, and the clean acquittal. That yes, that is Ramlar's case that taken care of. Yes,
that will not apply to you because you were already you suffered dismissal order much before acquittal.
Yes, but yes.
What is your explanation for all these years for keeping away?
That is some delay has been actually
how many years of delay?
But 2012 has the entire proceeding has closed. And he had approached the authority, but the due to the
your appeal is negative.
Yes, my appeal is negative. No, my appeal, yes, my appeal is negative.
Yeah.
Therefore, I approach this honorable court. Lashman is my judgment. Lashman for the judgment.
Will refer to every judgment. Two more judgments. Our judgment will add to that. Right now.
But this 75 to 72 years old man, my lord.
He will become 92 after 20 years. But can it be a corruption? But you argued very well. I will appreciate it. I'll write one sentence about your performance also. Mainly be seated. Permit him to write. Yes. He has in one sentence he has answered. 311 2. And he kept quiet.
Lakshmi, I pray one thing, Lakshmi, call this another day. So
that I never do.
I'll just examine the matter. Delay so that Lakshmi is sticking on the point delay.
Installment. This is not a bank where it will go for recovery on installment base. Hearing and overing. That's all. Right now. Dismissed employee. What was he?
Yes.
Dismissed employee of an educational institution who was working as head saver. He is knocking at the doors of the court, seeking the quashment of renewal orders and reinstatement in service. Kindly be seated. Sit down. Sit down. First and foremost, learned counsel for the petitioner. Learned counsel for the petitioner very clearly argues that there was no disciplinary inquiry that was held before terminating the service on the wide allegations of alleged misbehavior with the girl students in an ashram. He was not permitted to participate. Don't disturb when I am dictating dictation. This is a contempt of the court. Please sit in. Yes. He ought to have been given an opportunity of participation in the subject inquiry, allegations being very wide. And there is absolutely no justification for passing an order under Article 302 of the Constitution of India dispensing inquiry. The petitioner having undergone trial emerged victorious in the criminal case in which he was charged sheeted for the offence punishable under Section 376 of erstwhile IPC 1960. In the circumstances, he has an eminent case for an order for reinstatement in service. So, some delay has been broken in approaching the court because of certain difficulties. So there is no limitation, specific limitation period for knocking at the doors of writ courts. After his appeal against the order of dismissal was upheld way back in 2012 by the appellate authority. So he being aged 72 years now, come on, court should view the delay with the leniency and take up the matter for consideration. The rest of the dictation afterwards.
I but delay is not there. I approached to that is I approached immediately after the order of the dismissal authority. That is the appellate authority.
No, appellate authority is dated.
But that is the double petition number 2021-13.
So when it was decided?
Decided 2012. Immediately I approached this honorable court. That's was decided and 15/11/20 the case was disposed of. So there is no delay. 15/11/23 that disposed of. But
15/11/23.
Yes.
But you filed it in 2025.
No. I approached to that 13 immediately after the order of dismissal.
No, that order is over.
No. I challenged the order of dismissal authority in 2013. Immediately after that, the negative.
But this is the 2025.
No, again, Lord, that was dismissed. Because that the previous counsel did not appear, that was granted liberty to file a fresh application. So I filed this. So no delay is there.
1 second. When it was dismissed?
Yes.
First petition was dismissed when?
15/11/23, Lord.
15/11/23.
Yes.
I should have sought for revival of the petition. How can you maintain another?
No. Liberty is granted. That was there.
15/11/23.
I filed the application.
1 second.
Next.
Dismissal of WP.
Yes. 15/11/23. And I filed the application to 2021-2013 immediately after the order of the dismissal authority. So there is no delay at all. So there is no delay. That is I was wanting to.
15/11/2023 is what order?
That is the case was disposed of, granting liberty to file fresh application. If that was the Lordship granted liberty, that is I filed the writ application.
Second, 15/11/23.
Yes.
And you filed the writ petition when?
But I filed that on 15 law. 425 law. Yes. That's the
delay.
Yes.
Delay.
The delay is filing after challenging the dismissal authority. No, I immediately challenged that order of the dismissal authority 13.
No, but petition was dismissed on 15/11/23.
23.
You were given liberty to revive or file another petition.
Yes.
That is understandable anyway. That is the order of this court.
But Lordship said that the delay of after challenging the dismissal authority, no, that is not delay. Delay, I immediately
after dismissal of the petition.
No, after dismissal, yes, by the dismissal authority, by appellate authority. That was dismissed.
I'll come back.
Yes, please. Okay.
Yes, take down.
I may be pardoned to make a mention about it. Item number 61. I may be permitted to withdraw, Your Lordship.
61?
Yes, Your Lordships.
WP number?
No, that is CRLMC. CMAPL. I beg your pardon.
Yours for the petitioner appellant?
Yes, Your Lordship.
Petitioner or appellant? What is that?
Appellant, Your Lordship.
Appellant?
Yes.
Any question? This was
Obliged.
Please to send copy of this order to the respondents by speed post immediately.
Yes, ma'am.
Item 35.
You say that there is no delay.
No delay.
Understood. Next. Any other point you wanted? When judges are dictating, you are not supposed to interrupt.
Sorry, I'm extremely sorry. Not for that.
Sit down. The petition is dismissed on the following grounds. Number one, on the dictator, further again, the petition is dismissed on the following grounds. Number one, the school in question is run by ashram, and girl children study there. Third, the allegations against the petitioner are very wide, and the gist of them is as under. Just leave it. Next paragraph. In respect of the allegations, a preliminary inquiry was held, followed by a regular employee, of course, giving no opportunity of participation to the petitioner, inasmuch as the competent authority had issued Article 311(2) order. First off, referred to Apex Court decision on 311(2). Next point. One sentence, your friend. This order as such is not put in challenge. Next point. The contention that on the acquittal of the petitioner in criminal case for the charge of offence punishable under section 376 of IPC 1860, the respondents ought to have reinstated the petitioner if difficult to agree. First, reasons for this are not ought to seek. Small a. The disciplinary proceedings and the criminal proceedings may proceed on the same set of facts and may be structured on the same substratum, has been settled by the Apex Court law. First, the quality of evidence, the nature of the proceedings, and the court holding them, and the consequences are pulls asunder. One more second. Even the burden of and degree of proof are pulls asunder. Next paragraph. The vehement reliance of the petitioner on Ramlal does not come to the aid of petitioner in as much as the acquittal of the petitioner is not demonstrated to be an honorable acquittal by the criminal court. Third, in any case other than honorable acquittal, the ratio of Ramlal cannot be. First, the Karnataka High Court in decision. Mr. Monty, do you remember that Karnataka High Court judgment went to Supreme Court end of October on honorable acquittal?
GM Tank.
No, Tank is considered in that. Which Ramlal also is considered. In V.V. Rudrappa, what's the state of Karnataka? The deeper aspects of the matter have been discussed. And it is observed as at that time of your someone said. Okay. Next one. The vehement submission of the counsel for the petitioner that when serious allegations are made, the participation ought to have been permitted is a bit difficult to agree with in as much as that amounts to
upsetting the order and made under Article 311(2), which is not put in challenge. First, the factual aspects of the matter having been looked into by the disciplinary authority and the appellate authority thereafter, a writ court exercising supervisory jurisdiction cannot undertake a deeper examination of the same again, notwithstanding some arguable errors of insignificance in the case. First step. What you have to keep in mind is the apprehension of children and their parents. If persons of petitioner's nature are allowed to teach or do some work in the institutions of the nation, no parent nor child can have good sleep. And that is not a good thing to happen in a welfare state. First, in the circumstances, petition being thoroughly devoid of merits, is liable to be dismissed, and accordingly it is.
With the Lord's permission, can I make one submission? That so far as the major punishment is concerned, Lord, in our rule, Rule 15 should follow. This is a major punishment. Before imposing that punishment, the paraphernalia has to maintain. But may I read the section 50, Rule 15, so that will be Rule 15.
Yeah.
Procedure for imposing major penalties. Without prejudice to the provisions of the Public Servant Inquiry Act 1850, no order imposing on a government servant any of the penalties specified
can be imposed.
Can be imposed. But then this disciplinary authority shall frame definite charges. But it should be definite, no charges will be framed in this case.
Now, all that will apply in the absence of an order under 311(2). That's what one sentence is saying.
Yes, that's the Article 311. May I read that Article 311? What it says?
Yeah. In fact, the authority has referred to a decision of the court also.
But this rule has followed this constitution.
Yeah.
311(2), it says that what is the rule?
For the reasons to be recorded.
But here, Lord, I see that no procedure has been followed. So, Rule 15 is mandatory.
11(2).
Yes. Yes. Dismissal, removal, or reduction in rank of persons employed in civil capacity under the Union officer. No person who is a member of a civil service of the Union or an All India service or a civil service of state or holds a civil post under the Union or state shall be dismissed or removed by the authority submitted to that by which he has appointed. 2. No such person as aforesaid shall be dismissed.
Not suffered. Subordinate to the authority, as I remember.
Well, no such person as aforesaid, that is limited. Aforesaid shall be dismissed or removed or reduced in rank.
Right.
Yes. Except after inquiry in which he has been informed of the charges against him and given the reasonable opportunity. So here is the case, no charge has been framed.
Go to next.
Yes. Reasonable opportunity of being hired in respect of the charges. Yes. Then, provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry. And it shall not be necessary to give such person any opportunity to make it clear. So there is no evidence at all. In this case, that is inquiry is made by committee and based on that report, order of termination passed. So that is complete. That is violation of Rule 15.
Committee has looked. There is a preliminary inquiry report.
Yes.
There is a final inquiry report.
Yes.
Committee has taken, the authority has taken the decision.
Yes.
You took the matter in appeal.
Yes.
Appeal also you met the same fate.
Yes, appeal authority cannot, but I know that is their department, they can, they never respond.
No.
Here, the case is a major punishment. That is the rule 15 is to be followed.
Major
that
charge and major punishment.
But
so 311 to proviso to 300.
So may I read rule 15, the enter so that Lordship can appreciate my contention, that what is my. But two, the disciplinary authority shall frame definite charges, that is mandatory. The judgments are there also. On the basis of the allegation on which the inquiry is to be held, such charges, together with a statement of allegations on which they are based, shall be communicated in writing to the government servant, and he shall be required to submit within such time as may be specified by the disciplinary authority, not ordinarily exceeding 1 month, a written statement of defense, and also to state whether these are to be. So these are demanded no notices we issued to file my statement, my reply.
All these rules stand eclipsed by order under 311 provision.
That's true. But that's
what courts have said. Otherwise, I would have said,
but these are the rules he has to follow.
To retain a person like him, he goes to the children where the ladies, children are residing.
My lord,
he drinks, he calls them to sleep beside. Can you see the allegation?
Yes, allegation there.
Your question is,
yes,
this should have been inquired in.
Yes.
Allegations can be anything.
Yes.
But it is not that simple.
That's true. I am equally supporting my love. I'm not
myself.
Yes,
I am asking myself.
I also support.
Can I send my daughter
to a person
such a school?
Yes.
No, can any of your friends send their daughters and niece to school of that kind?
Exactly.
Even if inquiry is held and you are dismissed from service.
But that apart from that, this is provided clause there. Provided he is involved. That provided means this rule 50 has to follow.
No, 50 need not be followed.
But the charge is not there. No, evidence is not there.
The proviso to 311, you did not read that. Dispensing with the inquiry. Constitution provides for dispensing with the inquiry. Dr. Ambedkar thought earlier that matters pertaining to disciplinary inquiry, etc., should not be put into the Constitution at all. They should be matters of ordinary legislation. Thereafter, Dr. B.N. Rao suggested, in terms of some constitution of other country, I do not remember which country, he said similar provisions are made in very advanced constitutions of some good jurisdiction. Therefore, we will put it into the Constitution itself. If you see B. Shivrao's Transfer of Power, 7 volumes. B. Shivrao is from Karnataka, as B.N. Rao was. Venagal Narsingh Rao, the constitutional advisor, was from my place. He was the constitutional advisor. Thereafter, he became International Court of Justice judge. Okay, Dr. Ambedkar brought him, saying that there is a duty to frame this. On his suggestion, they introduced this article. Therefore, these are many aspects of it. You may feel, but you may not be very satisfied with the reasoning of the court. But there are justice elements, which most of your friends will feel, no, this kind of person should not be sent back to the school at all. Children will not be safe.
But this should be given to some pension, not getting blood.
Dismissal.
But Lordship can modify that also. They can. But this
we'll
type
see
of
some good case we'll see. These are my notes. My judgment follows based on this.
Item 33.
Yes, brother. Yes.
In this case, I am challenging the rejection order dated 11/6/2025 by the annexure 15. Now, but fact is this, my lord. The petitioner was working as a assistant teacher, was appointed against the junior ACS post in the 85. Odisha Supplementary Education Rules provides that after 3 years and with the BD qualification, he to be promoted to the post of junior ACS. Initially,
Presently, in which post he is?
now he is retired.
Now retired.
Yes.
He retired when?
Retired 60, my lord.
Huh?
Retired in 60.
No, full date you have to give. Date, complete date you have to give.
Complete date I have not.
You're not having.
Yes. Who was 60, now he is 65, he retired now, he is 60. My lord, he was joined service in 85.
How many years he served?
More than 34 years.
85 to 2016.
Yes. 2020.
2014.
2020. He retired.
He retired in 2016, you said.
No, 20. 60 years.
At the age of 60 years.
Yes, my lord, fact is this, my lord. He was joined 85. Before entering into service, he has completed the BD. The rules say that after 3 years of complete the service, he is eligible for the post of junior S. The authority has not given, he has given in 2005. Against that order, they have made application to correct the year and the date because he is eligible for promotion to 88. The similarly situated the teachers, they have moved before the court and moved before the land tribunal. Tribunal directed to give granted promotion to the junior post. Accordingly, the government has extended the benefit. Lastly, we had an annexure we see for the moment. Annexure 6, page 34. The land tribunal on 16/9/2026 directed, see for the moment, page 53.
Directed for the moment, page 63. What is that sentence? What is your sentence? English sentence?
The judgment passed by the land tribunal by the annexure 6 dated 16/9/2016. The concluding paragraph of the land the tribunal is page 53, paragraph 9.
Similar.
Yes.
Identical
applicants and other similarly placed persons shall be promoted the post of junior SS. The tribunal had directed in 2016. The authority has not extended the same benefits. Therefore, the petition moved before this honorable court in 2022, and this honorable court of force.
Why they take it? Because other persons have been granted that benefit.
No, this is a very concase matter. Previously, he has moved before this honorable court. This honorable court directed to give granted a promotion within 3 months. By referring the judgment dated 22/24/2024. After that order, the OP number 2 has rejected that case. That case on 11/6/2025. The 16/6/1966 judgment of the land tribunal, the government has moved before this honorable court, and this honorable court has dismissed the government case on 28/10/2021.
Went to Supreme Court and SL also dismissed.
No, this honorable court has dismissed the case. Again, the government moved before the honorable apex court. Apex court has dismissed the government case on 25/10/2024. After dismissal,
therefore we are issuing notice.
Yes, the government has worked out the same on the 28/11/24.
Therefore, we are issuing notice to him so that he can.
Now, the judgment of this court is rejected by the OP number 2.
Now, this is a fresh petition.
No, it is the third petition.
Third has been issued in this.
No.
Therefore, it's a fresh petition.
This is a press matter.
It may be third round of litigation.
Third round of litigation maybe.
We'll issue notice to him.
Yes.
And then we'll hear him.
Yes.
Thereafter, we can pass the order. Issue the emergent notice. Learned AG is requested to accept notice for the opposite parties. All opposite parties?
All opposite
All government. First of all. Learned counsel appearing for the petitioner submits, and this court agrees that since this is third round of litigation, the same should be taken up on a priority basis. First, post this matter in the second week of September 2025. First, in the meanwhile, the OPs may file their objections. Counter. In which right to file one stands forfeited, and petition averments may be taken up with prima facie credence.
Well, item 41 also same.
41 is also same.
Same, identical.
41 also same order. Okay. Call along with each other. Yeah.
Item 37.
May I please, Your Lordship?
Yes, sir.
Your Lordship, the petitioner having qualification of a diploma in early childhood care and education, that is DEC from IGNOU, Your Lordship, from the year 2020.
IGNOU is Indira Gandhi Open University.
Yes, yes. What happened in this case, Your Lordship, more than 1 lakh above students are waiting for appointment of the teacher of Bal Batika, that is, Your Lordship, Sisu Batika, Your Lordship. But what happened, Your Lordship, the petitioner moved before the concerned authority under Annex 3 and 4 series. And the policy is, there is a scheme.
Go to prayer.
There is a one of scheme, Your Lordship, that is National Education Policy since 2020, Your Lordship. The state government also.
Application in Annex A4.
That is, Your Lordship, 4 series, Your Lordship.
But in your prayer, you have said A4.
No, that is.
What no? In prayer, you have said A4.
The grievance application on Annex 4, Your Lordship.
Yes, therefore I said that one.
Yes.
Annex A4, if that application is considered.
No, that is still pending before the concerned authority.
If we direct them to consider the application in a time-bound way,
yes,
will it serve the purpose?
Maybe, Your Lordship, but the scheme is there, Your Lordship. That is a national scheme.
Anyway, that scheme is there.
Yes.
Your application has to be considered in the light of the scheme.
Yes.
Is it correct?
Yes, Your Lordship.
We will today only direct them to pass orders on your application.
Yes, fine, Your Lordship.
Right?
But what happened, Your Lordship, the state government authority issued the one notification for appointment of that is non-teaching staffs. That is under Annex 1, Your Lordship. Whereas they have not any notification issued by the authority for appointment of a teacher, that is a teaching staff.
Your
application,
that. Kindly take us to Annex 4.
Yes, Your Lord.
Let us see.
Yes.
Take me to Annex 4. Annex A4 is what? Annex 4 is what?
Your Lordship, that is the education on Annex 4, page 25. Yes.
What is your prayer? Therefore, we pray
to consider the regarding create vacancy and take step immediate recruitment.
Kindly read your Annex as it is. Don't add your words.
Yes. No. That is, I'm reading in subject matter, Your Lordship.
No, last paragraph.
Yes, Your Lordship. Therefore, we pray kindly concern our genuine case.
What is concern means?
Means, Your Lordship, more than DC students are there, Your Lordship.
That word appears to be considered. Is it not?
Yes.
Mindlessly, word concern is used.
Yes.
Anyway,
that is concern.
Therefore, we pray kindly concern our genuine case and provide opportunity to dissent.
DC and entity students.
Constitutional fundamental rights of the employment. With that, we best efforts in Odisha. This representation is for what?
For appointment of the teacher, that is Bal Batika. That is a system.
Kindly read your subject.
Yes, Your Lordship.
Prior to consider regarding create vacancy, take step immediately. Why vacancy can be created by shooting to death those who are appointed. They should be shot dead, or they should be mass removed. Otherwise, otherwise vacancy will not arise.
Yes. No.
So you have to provide a pistol also.
No. This is what happened, Your Lordship.
Pushed it much big.
This scheme is since 2020, Your Lordship. They have not issued any notification, Your Lordship, till date, Your Lordship.
Minister has to take the decision in that.
No, director, Your Lordship, or commissioner of education, school and mass, Your Lordship.
You have sent copy to commissioner also?
Yes, that is opposite part number 1, Your Lordship.
Where is that address to?
Next page, Your Lordship.
Page 26, madam.
Page 27, Your Lordship. That is commissioner, secretary, department, school and mass education.
Brother,
The language may not be good because we are not from England.
Students, sir.
Is it not? We are all Indians. And English is a foreign tongue. But if you read all this, it makes some sense, regardless of grammar, etc. We are not deciding whether things are done in accordance with rules of grammar of Wren and Martin. We are deciding whether a person has brought to our court some genuine grievance. There appears to be grievance. It is pending before the concerned authority. Let him consider that in a time going to be Mr. Monty.
My lord.
Can it be done?
Yes.
We'll do that.
Yes. Ventilating all the.
That's one. And if they ask the translation in Odisha, you have to give because they may not be able to understand.
Yes,
I have not fully understood.
Yes.
But coupled with your argument, I'm just imagining this may be your grievance.
Yes, complex.
That way. Only one petitioner.
In this petition, one petition and a sub-item would also similar, Your Lordship.
All these sub-items are similar?
Yes, 3 students are there.
In this batch of 3 petitions, the fact matrix and the law broadly appear to be same. First off, please be seated. Yes, kindly sit. What is that education? Their education. Sit and answer. This is not primary school to stand up for everything. This is a court and you are members of the bar.
Yes, sir.
Sit and answer.
Yes.
Yes. What is their educational qualification?
That is, Your Lordship, diploma. Diploma in early childhood care and education. That is DECE.
Childhood care.
Yes, Your Lordship.
All right. Petitioners are complaining before the writ court as to non-consideration of their representation dated 12/6/2025, address it to both the higher education minister of the state government and the commissioner cum secretary, Department of School and Mass Education, Srimati Shalini Panditji. What is that? Name of the school.
Name of the secretary.
No, name should not be.
Yes.
Education, Government of Odisha.
Students are rated.
Seeking appropriate orders for engaging their services on the ground that there is a perennial need of such services and that they possess the diploma in early childhood care and education which would enable them to teach preschool level children. First up, Learned Counsel for the petitioner argues that the said representation ought to have been met the consideration at the hands of the official respondents, and that having not happened, this court should come to the aid of these clients. First, next paragraph. Learned Standing Counsel, Additional Standing Counsel on request appearing for the respondents initially opposed the petition, contending that in the absence of right to appointment, court cannot direct consideration of representations wherein request is made for appointment. First off,
Having opposed the petition, now in all fairness, he agrees with the suggestion of this court that the subject representations need to be considered by the competent authorities in accordance with law and within a reasonable time. Merits of the matter being kept open. First, next paragraph. In the above circumstances, this petition is disposed of, prescribing a period of 8 weeks for taking the decision and communicating the same to the petitioners in writing. First of all contentions of the parties are kept open. Next, last one paragraph. It is open to the answering respondent to solicit any information or document from the side of the petitioner or the required departments, concerned department that would facilitate taking a decision in the on the subject representation. However, in that guise, delay shall not be broken. First of all, no costs.
May I pray one thing, Your Lordship? That scheme may be mentioned, Your Lordship. Under that scheme, Your Lordship. There is a scheme, Your Lordship.
One sentence before next paragraph. This I will not ask in court should come from next paragraph. Keeping open merits of the matter. Merits of the matter being kept open. First of all, the consideration has to happen in the light of the scheme. Which is that scheme?
That is in National Education Policy 2020, Your Lordship.
A scheme evolved through promulgation of National Education Policy 2022. 2020. And such other norms.
Grateful, Your Lordship.
Pass over item 26. When Mr. Naik has some personal difficulty, the matter may can be adjourned to next week.
Then to next week. Call after 2 weeks at the request of arguing counsel who pleads difficulty.
Item 38.
And I'm praying for adjournment for 2 weeks.
2 weeks. Yesterday also you took time on matter. You appear to be expert in taking time or what? 3 weeks at the request of. Yes.
Item 39.
May I please, Your Lordship? When the petitioner filed this writ application challenging the inaction of the opposite parties in denying the petitioner for getting benefit from the MECP schemes.
MECP matter also posted to 4
issue emergent notice. The additional standing counsel is requested to please for the respond. Any private parties there?
No.
No private party.
Private parties.
All this matter on 48. Other matters are posted on 48. On 48. When other similar matters are stated to be posted. Also. Give copy of the petition if he needs.
Extra copy I will show.
Item 40. May I please, Your Lordship?
Yes.
This petitioner is a retired senior typist of Orissa University of Agriculture and Technology. He was initially engaged in the year 1989 in a contingent paid employee. Your Lordship, his services was regularized in the year 2006. Thereafter, he continued and he was given retirement by attending the normal age of superannuation.
Retired on?
22 years, Lordship. There is annex 12 in the year 22.
Why is he here now?
My Lord, sorry, my Lord.
What he wants?
That is, Your Lordship, his pension has not been properly calculated. That is, the reason is that, Your Lordship, there now the university authority is taking a stand that you will be covered by CPF that is contributory pension scheme. But my submission, the employee submission is that, no, I was given appointment in the year 1989 and my services was brought over to the regular establishment in the year 2006. So my service condition and pension will be guided by Orissa Civil Service Pension Rule 1992.
Which the university has adopted.
That is, the university has adopted, and Annexure 16, other similarly placed employees, they are now getting that
those
benefit.
who were appointed with you.
My lord, with me, your lordship, in the same university. That is. So notice it to be issued because this is second round litigation and first time admission it has been issued.
Emergent notice. Learned AGA on request accepts notice for respondents 3, 4, 5.
My lord.
Emergent notice to 1 and 2. Returnable within 3 weeks.
1 and 2 to register post, because that is the register Utkal University and sorry, post, my lord, it's obliged, your lordship.
Item 42.
Item 42, my lord.
Yes.
Petitioners are the non-teaching employees of the Berhampur University. They are challenging the notification under Annexure 5, where the opposite part number 1 government has decided to create 163 post of junior assistant and has decided to abolish post of senior assistant and section officer, my lord.
How you are agreed by that?
Because, my lord, prior to issuance of annexure notification under Annexure 5, my lord, Annexure 4, Annexure 3, my lord, have a glance, page 36. Page 36, the government has directed the university to furnish the information of the non-teaching employees regarding rationalization of non-teaching posts, my lord.
Read that section which gives power.
My lord, in portions of section 22 of the Odisha University Act, they have abolished the post. But my lord, section 22 of the University Act, my lord, may have a glance that I have quoted.
No, if they are abolished, how you will be aggrieved?
Because my lord, we will not get any further promotion, my lord.
There is only question of chance. Chance of promotion is not justiciable.
Because under Annexure 1 series, my lord, the advertisement was issued for the post of junior assistant for 3 universities: Sambalpur University, Utkal University, and Berhampur University. Some of the petitioners applied pursuant to that advertisement, that is under Annexure 1 series advertisement.
But it's a policy decision. Government wants that these posts should go.
But my lord, that has to be in pursuant to section. The section 22 says only for creation of post and not about abolition of the post.
Power to create under section 21 of the General Causes Act includes power to abolish also.
My lord, but my lord,
General Causes Act.
My lord, right now I do not have the General Causes Act.
General Causes Act. Go to Google and take a Google of that section. Section 21 of the General Causes Act says power to do a thing includes power to undo a thing. Therefore, they have power to create, which includes power to Srishti and Laya are read in section 21. If you can make Srishti, and Laya also will follow. That is the policy of section 21.
Accordingly, Annexure for the Berhampur University has mentioned that the continuance of the post is required, my lord. That is at Annexure 4, page number 39, my lord, have a glance. Page 39, serial number 19.
It is said like that?
Yes, my lord.
Where is that?
Page 39, Annexure 4 starts from page 37, page 39, my lord.
Section officer.
Yes, my lord. Section officer, 25, level 10, regular promotional, existing cadre, required.
Take notice. Brother, take notice. Because abolition of post, it may diminish the chances of promotion. Apex Court in 2 decisions said, at least employees should get at least 2 promotions in their service. If that is going to be affected, then court has a role to play.
My lord,
or the other...
my lord, in page 60, my lord, the Berhampur University, after the abolition of the post...
All right, now issuing notice.
My lord.
Still you want to argue?
No.
I appear the applicant 1, madam.
You appear for response number 1?
Madam.
OP1?
It's madam. Department of Higher Education. VC and
Learned AGA Yes, additional standing counsel on request accepts notice for first respondent. First up, issue emergent notice to respondents 2 and 3. Returnable within 8 weeks.
Item 43.
43 may I plead, my lord.
Yeah.
In this case, my lord, I'm instructing to appear for the contesting opposite partner of 4. Today I'm filing my request. Let him solve a copy and
A copy. But notice is issued now.
No, my
But
lord.
how can you appear without notice? Because suppose if I dismiss at the admission,
I'm instructing, I'm not appeared.
that your role arises after court makes up a mind to issue notice.
Yes.
Not otherwise. What is this matter, brother?
My lord, this is a matter, my lord. Here the petitioner is aggrieved by the unwarranted interference in the administration and the management of the Christ Collegiate School, which is a minority education institution, which is
Minority institution.
education institution, my lord.
Minority educational institution.
Yes, my lord. Wherein the opposite party number 3, who is the district education officer, by overreaching his authority, has appointed the opposite party number 4 as a headmistress in charge of the institution, my lord.
Administrator.
Headmistress in charge.
Administrator. Who has the appointing authority?
The petitioner, my lord.
Educational institution.
The petitioner, the Cuttack Christian Education Board, my lord, who is the apex body who oversees the administration and
Yes, minority.
yes, my lord.
Then Manipal Mahe judgment is applicable.
Our own High Court judgment is also applicable, my lord, which is under Annex 6, my lord, wherein the issue has been settled in presence of the district education officer, wherein this Honorable Court, after hearing all the parties, has decided, my lord, that the CCB is the appointing authority for the headmaster or headmistress of government cannot interfere with regard to the appointment of the headmaster. Government can only interfere with regard to the education standard and other policies, service and conditions.
Manipal judgment. There are 3 judgments of the apex court now. Saint Xavier.
That has been quoted.
And Saint Mary. Saint Mary.
That has been quoted in Annex 6.
These judgments.
Yes, my lord. That has been quoted, my lord.
Take notice, brother. They are minority institutions. To found and administer the institution, which is that article 29 and 30.
Article 31.
30. Found and administer. Therefore, ordinarily you may not interfere. Let us see how it happens. How many respondents?
Total 4, my lord. 3 are state. Opposite party number 4 is a private.
Private.
Whose appointment is under Whose appointment is under
appointment is under
Yes.
You appear for our court. Issue emergent notice. Learned additional standing counsel accepts notice on behalf of respondents 1 to 3.
1 to 3.
Learned panel counsel Shri. So and so accepts notice for response number 4. All in the second week of September 2025.
I filed an IA, my lord.
For stay.
For stay of the.
When the order is made.
Order was made on 26/6/2024. This is second round of litigation. In the first round of litigation, I have raised a specific ground that the order of appointment was never communicated to the petitioner. Only when one of the teaching staff of the institution was contesting before this Honorable Court, in their counter affidavit, this district education officer brought this order to the light of the day.
Otherwise, you would not have noticed it.
Yes, my lord.
No opportunity need be given to you before appointing any teacher.
For appointment of teacher, the management of the school is the appropriate authority.
Where it is, show that.
My lord, Annex 1, my lord.
Page number?
Page number 26. That's the Constitution of the Cuttack Christian Education Board, my lord. The relevant portion is that, my lord.
Which paragraph?
Page 31, my lord. Article 10. D. Page 31. The headmaster of the school and the principal of the college should be Christian and be appointed by the board. Board herein is the present petitioner, my lord. And the appendix B to the constitution also states that page 43. Appointment of the headmaster of the Christ Collegiate School, Cuttack. The headmaster of the school shall be appointed by the executive committee of the Cuttack Christian Education Board, who shall determine
the counsel appearing for the petitioner drawing attention of the court to a catena of decisions of the apex court, including Manipal Academy of Higher Education versus State of Karnataka, etc. Followed by Inamdar versus so. And also followed by a coordinate decision.
Yes, my lord. Under Annex 6.
Decision
Under Annex 6.
at Annexure C. Annexure 6. Submits that the institution in question being founded and administered by a religious minority, ordinarily, the state cannot intervene, subject to all the exceptions. First, he also draws the court to the paragraphs of the constitution of the body in question, which has founded and is administering the subject institution, to the effect that the appointing authorities or the board, appointing authorities to the posts in question or the board is the authority, is the board and not the government. First off, a prima facie case is made out for issuance of interim relief. First off, next part, in the above circumstances, the impugned order is stayed till the next date of hearing.
And the name so forwarded under Annex 12, which has been forwarded by the petitioner, that has not been approved.
Order. And the proceedings taken in furtherance of that are hereby stayed.
May I submit one thing? Your Honor, yes.
You are not entered caveat.
No, not caveat, but my appointment is on the challenge. Only one submission, legal submission. Your Honor,
no, you are not on caveat. We need not hear you.
Only one submission.
The caveat meaning will run away. The meaning of caveat. Caveat is applicable to writ proceedings.
So far as my interim order is concerned, I am only submitting that my law friend has shown that provision of the bylaw which relate to appointment of regular principal, headmaster. Here, my lord, the annex or impugn order relate to in charge headmaster.
Where is your power? Power to appoint into, power to make in charge arrangement also.
Because of this large number of employees have not got the salary. Therefore, they made it.
That you abolish the institution.
Because the institution is an aided.
Anyway, you file your objections. You are not entered caveat also.
Another part, my lord, he has suggested a retired person as the headmaster of the in charge
the private institution. Constitution gives that power. What we should do?
No, not the private one. This is an aided institution. It is aided institution. And it's governed under the set of rule, my lord. And the rule prescribed retirement age is 60 years.
Why can't you read section 148 capital A of CPC?
My lord, caveat.
You enter caveat. I would have heard you. Now you make application for a getting stay.
So you also make because sorted.
Bless me.
Yeah.
Let's say item 44, there are two items, Lordship.
Yeah.
And both are teachers. They have been transferred on the recommendation of the local MLS and MPs, Lordship. There is a circular by the state government. Lordship, can they prepare the circular that is at Annexure 4, Lordship, for recommend kindly see. Then I'll go to Lordship, Annexure 4. Lordship, it's running page 43 of my brief, Lordship. Lordship, here the state government has taken a decision empowering the local political leaders, Lordship, to interfere with the transfer of these school teachers. Lordship, I'm reading, Lordship. I'm directed to say that the government, after careful consideration, Lordship, page 43, Lordship. 43, Lordship, Annexure 4.
Which paragraph?
Lordship, first paragraph, I'm directed, Lordship.
I am directed to say that.
Say that government, after careful consideration, have been pleased to give discretion to the honorable MPs and MLS, public MLS, Lordship, to recommend up to 15 most deserving cases of the transfer of teachers that shall include both elementary and secondary, pertaining to their constituency area, to the concerned collector of the district for disposal of the same by the district level transfer committee during this transfer session subject to the following conditions. Let's say they have given the conditions of lordship. First says lordship.
Yes, all right. I have read that.
Lordship. Then lordship.
3, 4, 5.
Lordship. So my humble submission, lordship, let I come to lordship, clause 6 lordship. That is perhaps important for my case. All the proposals should be submitted and disposed of during this transfer session, the 15th May to 15th June. This is the guideline of time frame they have done lordship. But my humble submission, this is a beneficiary lordship only to accommodate the needy teachers lordship. Perhaps this circular has been made. But now they are using it in lordship political consideration lordship.
Who are you?
Lordship, I am the teacher lordship. I am a teacher lordship.
Your teacher.
Lordship.
And transferred at the instance of MLA.
MLA's lordship.
Pursuant to this
letter lordship. Lordship, can you come to lordship slowly?
What's the process? Why are you in hurry?
No, sorry,
are you going abroad?
No, extremely sorry, lordship.
Evening at 5 p.m. any flight schedule.
No, sorry, extremely sorry, lordship.
Be slow.
Lordship.
Be slow.
Then lordship, come to page annexer P, page 42, lordship.
1C.
Lordship, 43, annexer 3, lordship, page 42.
42.
2, lordship. That's official dated lordship 21st July 2025. In pursuant to the notification dated 14/25.
What does it say?
Lordship, that notification is refers to lordship, this notification under annexer 4, lordship.
That transfer is made pursuant to that only?
That only, lordship. School of Mass Odisha, as recommendation of Honorable ML and MP, lordship, they have referred to lordship. Kalahandi duly received from the collector Kalahandi and Honorable MP Rajesh Sabha duly received the Director Elementary Education Odisha such and such by letter number such and such, and on alternative ground duly recommended the district level transfer committee meeting held on 14/7/25. The following elementary teachers are hereby transferred and posted as such in the school mentioned against their name with immediate effect, lordship. And here, lordship, I am lordship at serial number 3. 3 and no, not 3, sorry, lordship.
But you have marked 3.
Lordship, that is prior to filing that has been marked, lordship. Sorry, I'm extremely sorry, lordship. That is 4 and 7, lordship.
4 and 7.
4 and 7. If lordship see the peculiar to this order, 7, lordship, is a headmaster, but they have been shown as an assistant teacher, and from the upper primary school, he has been transferred to higher school, lordship, high school. Lordship, see the peculiar to this order. And they have been, lordship, thrown him out to more than 100 kilometers. Lordship, his wife is suffering, lordship, since long, lordship, I have given.
What do you say? How the political leaders like this should be given power to recommend?
The policy decision of the government.
What policy decision? Under which section? Which provision of law?
That is not there, my lord.
No provision. File objections.
I'll take interruption.
They see, you just see in during Margaret Thatcher's period, and the Parliament of UK passed a resolution saying that she should be granted PhD. And I think Oxford University said, which is this Parliament to say that whom we should give PhD and whom not to? They simply said no. They rejected, the Senate rejected Parliament's resolution. Otherwise, depending upon political inclinations, affiliations, the transfers will happen, not on the object of bringing best of the teachers to the school. The fate of the nation it depends upon the quality of education we give to the people. That's the reason when after the Second World War, when people wanted to felicitate Churchill, Winston Churchill, Prime Minister of the country, he said, don't felicitate me. Felicitate the teachers of Harrow and Eton School, from which our military officers come from. Prime Minister said like this. So education is very important. If all political people are, I have great respect for them because they are popularly elected. The question is, can the transfers be made at the instance of MLAs and MPs?
That is not only 10 to 15 persons they have to recommend, my lord. Considering there are problems, my lord.
That suppose somebody deeper consideration is required. I don't know
without such thing. Any parallel to this decision anywhere in the country where MLAs and MPs are given power to recommend transfer? They can be members of education board, development board. We can understand that. But I don't think that there is any parallel to such a decision in any of the states. I do not know. I'm only saying I do not know. But let it by matter first consideration. But heard learned advocate appearing for the petitioner, so advocate says so appearing for the petitioner. He draws attention of the court to the so-called policy decision of the government, which permits MLAs and MPs recommending 15 deserving cases of transfer of teachers. And in pursuance thereof, the transfer of the petitioners has been effected. First of all, he argues that there is no authority nor justification for a so-called policy decision as reflected in the letter of Joint Secretary to Government circulated amongst the Director of Secondary Education and Director of Elementary Education, Odisha, Bhubaneswar. Why the letter dated 7/5?
Let's 13/5, let's do that.
But letter is signed on 7/5 or what is this? 13/5.
13/5, let's
13/5/2025. A copy whereof awaits at annexure 4. First off, he also tells us that pursuant to this letter, the transfer of his claims has been effected and the same is unjustified. Unjustified. First off, there is a case made out for issuance of notice and grant of reprieve as well. First off, next one, issue emergent notice and interim order of stay of subject transfer relating to, so far as the petitioners are concerned, comma, till next date of hearing. Yes.
Second case, that's the same lot.
ASC accepts notice for
both cases, lordship.
Both the cases are same?
Same, lordship.
Call along with each other. Same order.
Lordship, grateful, lordship. Well, may I come get a course of day, lordship, so that I can.
Interim order, na? Interim. Send that today.
Lordship, grateful, lordship.
Web copy of the order to be acted upon by the respondents at site.
Grateful.
Item 45.
Isn't matter.
Yes.
Does this matter become next week?
You want next week?
Yes.
Not ready today. Wait. Call week of the next at the request of agreeing counsel for the petitioner.
Item 46.
Yeah.
This is a retired teacher, man.
Teacher.
In the year 2012, he has retired from the service, man. And I have been accumulated pension, man, of rupees 2,15,000. And I have challenged on before this court, man, honorable court, man, challenging the deduction of that.
Deduction or recovery?
Recovery.
Recovery. On what ground they are recovering?
They are recovering for more than 10 years. After 10 years, they have to stop, madam. But beyond 10 years, they are also deducting from my pension, madam.
Is it a case of commutation?
Yes.
You had commuted the pension.
Madam.
Commutation after 10 years, it is restored.
Not. They are deducting.
No. How much money you have committed? How much money you had taken?
2,15,000.
Which says after 10 years you cannot recover from the committed value.
My lord, as in the coordinate bench, my lord, in similar matter.
They have taken already.
My lord, already notice was issued.
Notice is issued.
Annex of 3 series, my lord. Page 20.
Any interim order granted?
Yes.
Issue emergent notice and emergent notice to the respondents. First off, learned ASC.
Approve 1, 2, and 3, madam.
1, 2, and 3. Appears for 1, 2, and 3.
4 notices.
4 notices.
Issue emergent notice to respond number 4. Returnable within 2 weeks, 3 weeks. First off. Next paragraph. Learned counsel for the petitioner submits that the coordinate bench of this court in WP number
252
has issued notice and granted reprieve, and therefore the same needs to be extended to his clients as well on the principle of parity. First, this court agrees with that prima facie. First one. Next one, in the above circumstances, interim order as has been granted in WP number so and so. Call this matter along with that WP. Yeah.
Next
till next date of hearing.
Next item, same.
Same. Okay. Item 48.
Permitted to
give or a judgment, which is that order, interim order.
Well, I have annexed.
Next.
Madam, there's 18.
19.
18.
18.
Madam.
Just Where's one? Issue notice, the DGA accepts notice for the respondents. First one, call this matter on 48 when similar matter said to have been posted.
Item 40.
kind of pass over, man.
Pass over? Yes.
50.
Lordship.
50 also sought pass over, Lordship.
Pass over.
51.
Lordship. I have filed the IA in this writ application. Only initially, this honorable court was pleased to give the protection by virtue of the order dated 28/11/2022. After pleading is complete, this matter was listed along with other similar matter. So thereafter, the interim order work could not be extended. Now, my lord, the petitioners are continuing in this service, only main prayer for regularization. And now their authority, DO, is threatening that unless until you get the extended order, then you will be debarred from getting the salary. Therefore, I have filed the IA for extension of the interim order, and your lordship put up any day for hearing to dispose of the writ application. But till then, my lord, the order, earlier order may be extended.
There was interim order earlier.
Yes, this is the.
There was interim order.
Yes.
Yes.
Then we have to continue that.
Copy of the IA.
This is the interim order.
Give copy.
Copy of the IA.
If you hold like
I should read. Copy means.
I to copy the read.
I already given in the.
You one more, sir.
Yes, I'm giving now. This is no problem. Yes.
Learned counsel for the petitioner submits that in which writ petition?
In the writ petition number 31410/2022.
22. A coordinate bench of this court had already granted interim order, limited interim order.
Order number 2.
Or wide order number 2. And
dated 28/11/2020.
On 28/11/2022.
Yes.
And somehow he could not get the interim order extended in view of tagging of this matter with another.
Yes.
Another. First off, he further submits that in terms of interim order, his clients have been continuing in the service.
Yes.
And now there is a chance of discontinuance, and therefore the interim order needs to be extended. in terms of application supported by the affidavit. First, this position is not disputed by the learned standing counsel, AGA, ASG, appearing for the answering respondents. First, once interim order is granted, ordinarily the same needs to be extended from time to time in the absence of any change of circumstance. First, apparently there is no such change, as argued at the bar. First, next paragraph, in the above circumstances, the subject application having been favored, interim order granted on
28/11/2022
is continued till the disposal of this case. First of all, post this case for final disposal in the last week of September 2025.
Yes,
Second sub-item is similar.
Similar.
My lord.
Order dated?
Same order, my lord.
Same order.
Same order.
Same order.
My lord, sir, with apology, item 50, my lord, just now.
50? Yes. Yes.
May I
But
place-
matter.
Yes, my lord.
Yeah.
Please, your lordship.
Yeah.
My lord, this is a case, my lord, where the petitioner is a student after passing +2 science, appeared for NEET examination, NEET examination for taking admission into medical UG course, my lords. My lords, the results were out. The first time, if your lordship will kindly see page 46, when the petitioner got the result from the website, took a printout, her mark was 540
out of
my lords, his rank was mentioned total out of 720, my lords. And subsequently, for the purpose, the next step is she has to register and participate in the counseling. And when she was supposed to register in the website, she took another printout. There, my lords, the total mark at page 47 came down to 90 for no good reason, my lords. There are no reasons were mentioned, my lords.
It is not percentage, it is percentile.
Yes, my lords, it's percent. My lords, I'm talking about the score, my lords. If your lordship will kindly see page 46, if your lordship will see the second box, which starts with physics, chemistry, biology.
Yes.
Percent total marks obtained out of 720. My lords found one?
Yes.
It is 540. 540. Lordship may kindly see the next page. That in the same place, total marks secured is 90. Two different printouts from the same website gives two different marks.
From 540 to 90?
Yes, my lords.
Okay.
And the rank also changes. And then, my lords, second grievance is, my lords, as per their own provision, they have to supply the OMR sheet, which I have submitted in my examination in my official email ID, which also they have not given. Therefore, I am not able to compare my answer.
Union of India. For Union of India. The first time it has come out.
Yes,
Yesterday I have received the brief. I will take instruction.
Well, this issue has become lots of kind.
When last date for admission?
My lords, for registration, my lords, I may be allowed to register. Counseling will continue. They have second counseling which ends at 20th August.
For registration, which is
for registration, my lords, 30th July is for registration. What I humbly submit, subject to your lordship's kind. I may be allowed to register myself, and subsequently, if I succeed in the case, then I may.
Who should get the registration? Who should get the registration?
The registration has to be done with the opposite party number, my lords.
But the exams will come to other court, na, to our court. Which course it is?
Well, it's an MBBS course.
MBBS, professional courses admission.
This is the examination, madam. This is the entrance.
Examination.
Yes, madam. The entrance. The course has not started. I have not taken admission. It's only examination.
But even those matters come to the other court.
Well, it is not. I am not claiming anything out of the professional course, my lords. Not from the university. It's only examination, my lords. And the allegation is against.
If this is a stepping aid to the course.
That's against. Yes, my lords.
Therefore, stepping aid goes to the jurisdictional court, roster bench.
I bow down, lords. I may not.
I'll send it to roster bench tomorrow.
As your lordship pleases, my lords. In fact, my lords, this issue has become an issue nationwide. Recently, on 28th, my lord, Delhi High Court has observed and constituted a committee for addressing the grievances of the students. This is not just for this particular petitioner. This same issue,
No, that's all.
along with others.
Very happy to entertain,
My lords.
but I have no power.
As your
because
lordship
of the
pleases. As your lordship pleases, my lords. I cannot submit anything on that.
Relates to NEET examination. And in the opinion of this court, it has to go to the roster bench. First of all, this aspect needs to be examined by the registry and needful to be done immediately. Since date for registration, the last date for registration is stated to be 31/7.
30th, my lords.
30th.
Yes.
30th. Post this matter tomorrow before the roster bench.
Educational institution. Yes.
I'm obliged.
Item 52.
I may be permitted to remove the defects within 3 days, as pointed out by SR.
The defect shown by the registry to be addressed within 1 week.
Item 53.
Item 53, there is a noting in the order that the item delivered not undelivered and it has not gone back to the OP number 4. There is a noting, my lords.
You have to address that.
Pardon, my lords?
What is that noting means?
Noting in the cause list, my lord, that item I have sent through the registered post to the AD. The AD and the undelivered post has not been returned back. That is the noting.
Notice.
That is the noting.
Notice has to be awaited.
Yes, my lord.
Await notice. Okay.
The date, my lord, can be fixed or is a revised also.
After service. Okay.
Item 54.
Lordship, I have filed an application for early hearing. The pleadings are complete. The counter has.
And matter is ready, ripened for final disposal. First time.
Lordship.
Therefore, application is allowed. You don't want allowing of the application. Application is allowed. And request for early hearing is accorded. First up. All this matter in the last week of August 2025 for final disposal.
Lordship, I have an oral prayer.
Yeah.
The matter relates to the recognition of a high school. This is the beginning of the academic session wherein the students are to be admitted. So, Lordship, I make a prayer that the students be permitted to be admitted subject to the final result of the writ application.
No, Apex Court said we should never do that. Tomorrow, suppose they are admitted and your writ petition is dismissed. What should happen to the fate of the children?
Can we fix it to some day in the next week, Lordship? With
What do
my
you say, brother?
friends' consent.
Yes. Because academic year starts when it starts.
If the session is going on, August is the admission up to August.
In the first next week.
Lordship.
Next week. Since urgency is pleaded.
Lordship.
In view of beginning of the academic year.
Lordship.
Okay.
Item 53. 53.
56. My lord, may I plead? My lord, in this writ petition, we are challenging the order dated 310 passed by
page number.
So, my lord, order dated 310 is page number 56, annexure 6.
There's 6.
56.
What is that order?
My lord, it is the order whereby my collector Koraput has nullified the legal heir certificate bearing number ELHC some 2026 256 401
wherein the deceased's wife has been granted the legal heir right. My lord, the petitioner is the wife of the deceased for which the legal heir was applied, and she is the second wife. My lord,
Wife of the deceased is called in English what?
Widow.
Yes. If you say wife, how I should feel?
Understood, ma'am. Okay. So was the second wife currently the widow? My lord, during the application for the legal.
But he says he quotes the condition. Come to para 4.
Yes, my lord.
Neither party has spouse living at the time of the marriage.
My lord. My lord, may I refer to para 11 of the petition?
Notice has not yet issued.
Yes, my lord. I am appearing for the OP number 5, the contesting party.
Notice issued already?
Yes, my lord. Notice was issued. I am already appeared, but our name has not been reflected. In this case,
so appears for respondent number, OP number 5. OP number 5. Write his name also. Spell your name.
Saubhagya Swain.
Saubhagya Swain.
Fine.
SWAIN.
Yes.
It's fine. The authorities who appears? You appeared for them?
Yes, ma'am.
Notice you have received already notice?
Yes.
Are you ready in the matter?
No, not ready.
We'll have this matter in the first week of September?
Yes.
Lord, I have filed an MISCA IA for vacation of stay order.
Let us see. The stay is there since last 1 year.
Yes, my lord.
The application to be considered along with the main matter. Since the interim order is operating for more than a year. Okay.
I have already served the counter affidavit to the petitioner. That
received. So you'll be ready for a final hearing in the first week of September.
Has to go September.
Okay.
Item 57.
Oblige, my lord.
Yes.
May I please, your worship?
Counter affidavit.
Because here in this case, the petitioner is essentially like a writ of quorum to paid for. Here the OP number 4, who is working as the principal in charge of a particular college, that is because he is not entitled to hold that office. For a moment, I want to draw your lordship's kind attention to Annexure 2.
What are the requirements for holding the office?
That is because here in this case, the principal in charge has been transferred on administrative ground. The reason is that is Annexure 2. You'll also come to page 23.
No, court is asking a question. Court is asking a question.
Yes, boss. Sorry.
What are the requirements to become entitled to hold the post of principal?
That is because in this case, what has happened, by one administrative order, this person has been transferred to a different college. But what he did was he challenged the transfer order before the High Court. There, initially, he got an order of status quo. So after getting the order of status quo, the governing body, president, he had relieved earlier that the OP number 4. So he just kept in abeyance. That order was kept in abeyance by the High Court. Accordingly, he has not been relieved. So thereafter, the ultimately the writ application has been not passed and has been disposed of as not passed. So ultimately, the transfer order has remained valid. Despite the same, because that person is still continuing as principal in charge, whereas
who are you?
Because I am the person who has taken over charge from the this person. Well, after his transfer, he was relieved and he was given the charge. That is, I'll come to Annexure 2.
You take notice?
No, notice has been issued. Notice has been issued because the collector, I am the sub-collector who is the governing body president. He has filed a counter affidavit even. And
we'll take up this matter on 20th of August.
No, for a moment, you also can listen what has happened because it is very serious.
I have not read the papers. I have to read the papers. Therefore, You will take up this matter on 20th of.
No, Mr. I humbly put it at the earliest because it's a very serious issue in this case. What has happened? 7 lady lecturers have raised the sexual harassment issue against this principal. That you, for a moment, also can come to Annex 2.
Why I believe you? You mean to say the court should doubt the liars?
No, no, sir.
We cannot. I'm part of the institution.
I'm grateful.
Your assumption is that nobody will mislead me. I believe you.
And thereafter,
so we'll have this matter
at the earliest.
At the earliest. Earliest is 19th of August.
6th.
6th not possible. Already I have posted many matter. Otherwise I would have taken that.
Because in this process that person is continuing, so
take it on 12th of August.
There is one interim. I have applied for an interim order.
In this, ordinarily in co-warrant matters, ordinarily interim orders are not granted. Read DD Basuan Constitution.
One order, will your lordship be pleased to? I just want to show your lordship the order passed by the Sound Court. In what way after the?
I will dispose of the matter on. We are fixing it on 12/8. 12/8. Okay.
In the meantime, the counter may be tagged because the counter filed by the OP number 3, that copy has been sought. That has not been tagged to the file.
Registry to put up a counter.
And the counsel appearing for the OP number 4, if required, of course, he is not required to file in counter. But even if he is required, let him file the response.
In the meanwhile, whoever wants to file the counter, is permitted to do it. Failing which, as on the next date of hearing, the right to file one stands forfeited.
I have filed a petition for the maintenance of the petition because he has raised that issue in the previous, he has filed a review petition withdrawn, and also he has filed 3IA. That was
on that.
Yes. My maintenance petition is there also. The read petition is not maintenance.
Let a person not placing the application is raising the maintenance.
Not placing when the government advocate said the interim is withdrawn. What I said do?
Reserve your arguments to 12th of August. Yes.
Item 60.
No, 60. You can argue from that side only. They are not leading place to you, na?
Please, my lord.
Yeah.
The petitioner has been working as guest faculty on contractual basis since 2020 to 2021. But the petitioner has continued in service up till May 2025. Now, my lord, a notification has been issued for engagement of the same post, contractual faculty, contractual guest faculty. That is at Annexure 10, page 36. My lord, by the impugn notification, they are seeking to replace one set of contractual faculty with another set.
That cannot be done.
That cannot be done, my lord. My lord,
I'll take instruction, my lord.
My lord, last order.
I'll take instruction.
You have instructions?
No, I not have instruction.
Last order may be seen.
Yes.
Instructions were sought for and an interim order was passed. The
interim order is there?
Interim order is there, my lord. Interim order was that the post may not be filled up. Now, what they have done is that when I communicated that interim order to them, they are saying that this only relates to the post. There is no interim order as to your continuance. So from the date I communicated that order on 14th of July, from that day onwards, they are not allowing me to continue.
Petitioner shall be permitted to continue in service till the next date of hearing. Okay. All this matter in the first week of September.
Sorry, number one.
62. Item 62.
None appears. Call after 2 weeks. None appears for the petitioner. Call after 2 weeks. Yes.
Item 49.
Oh, 16 is what is withdrawal. All matters, no?
I'm sorry,
49.
I'm challenging the order of transfer
Petitioner is a primary school teacher, my lord. There are 2 teachers in the school, one headmaster, one assistant teacher, my lord.
In the school, there are only 2 teachers.
Primary school as per the yardstick, my lord.
Yardstick means?
Yardstick, the prescribed yardstick.
Okay, pattern, the staff pattern.
Tapping pattern. My lord, the government framed the guideline, wherever surplus teachers are there, they are to be transferred to a deficit school where deficit teachers are there. They framed the guideline. But petitioner institution, there are 2 teachers according to their own strength of the institution. But in spite of that, petitioner was transferred by Annexure 5, my lord.
Annexure 5?
Annexure 5.
Page number?
28, my lord. Annexure 4, my lord. Page 28, sorry, my lord. Serial number 4, my lord.
Padma Charana Ratha.
My lord. And then
how many years you have put in service?
My lord, I was continuing since 2021 there.
Now, how long you have been in service?
I'm 2018, my lord. I was
When was she appointed?
I was appointed, my lord, in 2008, my lord. Page 13. 16/6/2008.
Any disciplinary inquiry, anything against you?
No, my lord, no. Nothing has been communicated. No.
But this is appealable order.
This transfer.
Transfer is
yes, my lord. Appealable order
of elementary education.
No, my lord. No, my lord. Because my lord, there is a provision. Can you see page 26, my lord?
Page 26. What it says? Appeal and review.
Appeal and review.
Director of Elementary Education, Odisha, shall be the appellate authority to dispose of the grievances related to inter-district transfer and intra-district transfer of teachers.
Next line is most important. The directors shall
also have the powers to review and modify.
Only inter, my lord. This is an intra-district transfer. So director cannot move.
Appeal you can file.
Yes, appeal you can give. Appeal, my lord, for those persons, those applications are pending for consideration of the transfer, my lord. My submission, my lord. Appeal, they can be filed by persons, those who request the authority for consideration of that transfer.
Now, where is that?
But can you see, the director cannot review the intra-district transfer. Here, my lord, my transfer has already been made, my lord. I have been transferred. I am challenging my transfer for modification or review. So director has lacked jurisdiction to review or modification subject to my acceptance. Director has no power to modify the intra-district transfer.
Yours is the intra-district.
This is the intra-district transfer, my lord. I am challenging my transfer. My application, no application is pending for consideration. So my submission would be.
Kindly read the sentence.
The director
also have power.
The also power to review, modify inter-district transfer.
Yeah, in addition to the other power, also means in English. In addition to the power given above, this also. Otherwise, also will die.
No, definitely, my lord.
You can kill the word from the dictionary.
Definitely, my lord. I'm not killing. My lord, my submission, my lord, the first sentence, my lord, kindly see.
While review, what appeal, because we have made that order in other matter. Within 1 week, you file appeal. And till then, they will not disturb you. Okay. The subject matter of this petition is substantially similar to the one in the number Mishra had argued.
Double visit 2020 or 25.
You can see 2020 or 25 between so and so heard and disposed of me this board wherein reprieve has been granted, relegating the litigant to the appellate authority in terms of paragraph 6 of what is this order?
Annexure 4, my lord.
Which you are read now.
That is the guideline, my lord. That is guidelines
of paragraph 4 of the promulgated guidelines relating to transfer. Next one, in view of the above, this petition is disposed of on the rule of parity
keeping the impugned order of transfer in abeyance for a period of 1 week, recount from history, and reserving liberty to the petitioner to prefer appeal against the same, wherein he can make the request for grant of interim prayer as well. First, in that connection, all contentions of the parties are kept open. And they heard the council say so, and let the DSC for the opposite parties. Yes, next.
Item 63.
My lord, I am challenging annexure 8. The order passed by 8.
8.
Yes, page 47. My lord, background is necessary. The petitioner was appointed in 1988.
This is, you are arguing for final disposal?
Yes, it is ready, my lord, it is ready, your lordship, because similarly situated person have already been regularized and they have received their claim.
Is it true? Have you regularized, you appear for the opponents?
Yes, I'm University, Utkal University, my lord.
Have you regularized the services of similarly circumstanced persons?
That is also some disputes are there. What happened, my lord? In fact, in 2013, the petitioner was...
Can I fix this case on 7th of August?
Not
Final
7th,
disposal?
Not 7th, my lord. Any other day. Any other, 6th, your lordship, fix it to 6th.
6.
Yes.
Well, 6. August. August 6th, not?
That will be fine. Yes. Obliged.
64.
64. I am for the opposite parties, my lord. My lord, the matter is ready for hearing, my lord. My lord, may be taken up any other date. My lord, senior is not.
First week of September.
My lord, as my lord.
Any date in the last week of August. Praying, my lord, as per your lordship's convenience.
Then we take this matter. 22nd.
Yes, ma'am. Yes, ma'am.
65.
My lord, I am appearing for 7 and 8. Which time will be done for final counter application?
First week of September. That's related. That's interim order to continue. Interim order to continue. Interim order you have. Let's then second week of September. Interim order to continue. Let's
56.
Wait, please, my lord. My lord, this is a matter with regard to rehabilitation appointment, my lord.
Rehabilitation of?
Appointment, my lord, under Utkal University. And my lord, they rejected my application on the basis that because my father did not held a substantive post, my lord. That is the only contention.
Compassionate appointment.
I am praying for a compassionate appointment.
The person under father?
Yes, my lord.
Father died in harness when?
My lord, father died.
Brother, whether a compassionate appointment is available to the for cases wherein the deceased was not holding the substantive appointment.
My lords, this matter, the answering party is Utkal University. I don't.
University.
Yes, my
lord. For Utkal University.
Utkal University.
That is the name of Mr.
Ramakan.
Taranand Patnaik. So,
this matter on 6th of August 2025 to enable counsel for the panel counsel appearing for the panel counsel of the university to comment on
Taranand Patnaik. Name is there, but
he has not appeared.
Yes, my lord.
So let him appear inform
Yes.
him. On 6th we are taking this.
My lord, there is a little inconvenience.
Which
on
date?
6th.
Which date?
My lord.
On 13th?
My lord, on 8th. On 8th of August, my lord.
Yes. 8th of August. All right. All right. 8th of August.
Yes, grateful.
Item 67.
The registry to send a copy of this order to the registrar of the university, correspondent university, to make arrangements for representation. But since his counsel is absent, but
67 made, please.
67. Yes.
I'm for the petitioner, my lord. I'm challenging Annexure 7, which is the disengagement order, my lords, wherein the fact of the matter here is, my lords, I was engaged as a junior teacher. While I was continuing in service, I was falsely entangled in a criminal case, my lord.
Case involved to what?
This is the criminal case.
What offense? Criminal case can be non-parking of parking in a non-parking area is also a criminal case.
My lord.
It is 302.
My lord.
302.
My lord, I was involved, I was entangled in that case, my lord. So I was enlarged on anticipatory bail. The fact of the matter here is that my mere involvement in a criminal case does not entitle the employing authority to disengage me from service, my lords.
You are involved in 302 case.
My lords, that is there. But this matter is actually covered by 3 judgments of this Honorable Court, which I have relied upon, my lords. Exactly covered. If your lordship may kindly see. Page
on that ground, they have disengaged you.
34. My lords, they have disengaged me because I was absent from service because of my involvement in this criminal case, which I time and again intimated them.
How long you were absent?
I was absent from 2014 till 2022, but I have continuously intimated them, my lords.
What, 2014 to 2022?
My lords, because in 2018 I was enlarged on anticipatory bail, my lords. The trial was still continuing. So the trial had not concluded, my lords. And that matter was eventually it was settled. But in spite of that, in 2018, this Honorable Court enlarged.
For 4 years you have remained 14 to 2022.
My lords.
That is 8 years. You have remained absent for 8 years.
Because
why should you be engaged?
I was no, my lords. So there is, my lords, my mere involvement in a criminal case, not because of the
ground. You got anticipatory bail.
In 2018,
you immediately come back to the job.
No, I was apprehending because if the trial trial was continuing.
Bail was order.
That was happening, lords.
26/3/2018.
26/3/2018, my lords. 26/3/2018, Annexure 5, my lords.
2018.
My lord.
23/6/2018. When you went back to the job.
My lords, I have till now not been engaged, my lords. I have till now not been reinstated in service.
To me, after you got the anticipatory bail, you should have at least at that time you should have gone. I told them, now I have got protection of anticipatory bail. Induct me in service.
Lords, after
from 2014 you are absent. Somehow it's arguable. Right. That I was trying to get the anticipatory bail. I was apprehending my arrest because the offense is very heinous. Therefore, I could not go. I can understand. We will see that. But after 26/3/2018, when did you go to them and told, take me back, I have anticipatory bail?
My lord, if your lordships may kindly refer to Annexure 8, my lords.
Answer our question.
My lords, that is what I have continuously intimated them in this order, my lords, that I have continuously approached them to reinstate me in service. So they have refused to receive all those letters and those.
Refused to, you could have sent by registered post.
Well, I have sent it, my lords. Annexure 8 is what I'm referring to.
Which date you sent that for the first time?
Well, it starts at page 51. The lord sees that is 21/4/2000. From then on only I have been continuously intimating the authorities. Because I was disengaged in the year 2014, my lords. And after that, your lordship sees the disengagement order also.
Charge sheet is filed now.
What's that? I have not taken instructions, my lord.
If charge sheet is filed, there is a prima facie case for the purpose of them.
Your lordship, may I just request your lordship to kindly have a glance at this judgment, my lord, which exactly covers my case, my lord.
We have already considered the coordinate bench and division bench in another matter. Therefore,
separate appeal which they went Kailash Chandra Behra matter, my lord.
I don't remember.
This is the judgment. If your lordship may kindly just have a glance at.
For such people, I do not give relief at all. Persons who are involved in 302 and charge sheet is filed. Suppose if no charge sheet is filed after investigation, then I feel I can be very lenient to you. Once police officers investigate and find out prima facie that there is a case against you and you are set up for a trial, for such people, we do not give. There are many good people who can work. You are accused is true. Your doctrine of innocence is confined to criminal court, not to the civil court.
Lordship may kindly refer page 45 minutes, the order minutes which have been passed.
In first week of September 2025. We will not grant the relief to the at least those who are whether charge sheet is filed or not.
I'll take instructions on that on the next date.
Item 68.
There are many good people without job. And if we offer the job to those who are involved in the 302, then how you should be controlled by the person who is engaging your service. You will tell him, I am 302. Be careful how to extract. It's impossible. Yes.
My lords, item 68, for some time to file counter ruling for
the second week of September at the request of.
Item 69.
May I please, Your Lordship? Now here, the state authority, the BTA authority,
There's one member of the bar who pointed out, when senior advocates appear, they have to give some stamp or something like that.
Now let me just clarify. Now we are giving the stamp. The secretary might have said that they introduce another 100 rupee stamp. That is to be given in the appearance memo itself. Appearance memo itself. But that has not been intimated by the Honorable High Court. So therefore that is by the Honorable High Court. Because the other stamp that was there, that has been accepted and incorporated in the rule. If you don't give that, there will be a defect. The stamp has not been included, but we can very well give because it is for the welfare of the bar. There is no harm in giving that 100 rupee per case.
Yes.
And here though the notices have gone, I think
We will, as well as the senior intimate that the matter has been listed today, my lords. You have already known the process will file it, lost may grant 10 days or 2 weeks time.
Your Lordship. For my deed as a private owner association who seeks demolition of my building, the municipal authority, the BTA authority, the state authority, Housing Urban Development Department are the authority who have to answer. He is an association of that flat owners who is seeking for my demolition. He doesn't have much say in the matter. The authorities has to answer.
I have not. I have not say because we are the last. So we are the last.
File the counter here.
The Lordship kindly see the
appearance along with my lord's counter.
let the Lordship kindly see the last orders.
That is true, but they have to.
How many times they have taken
It is
time?
not a question of taking time.
It is the authority who is supposed to defend their own order below. They are taking time usually in every occasion. And a demolition order has been passed in 2018.
Three mellows planning.
Why you are not filing the objection?
No, they were not noticed, my lord. Initially, they were not noticed. Your Lordship may kindly see.
1/7/2024.
Yes.
24 after that first time has come because earlier counsel was intimated but because the person the difficulty could not appear. That is why
A coordinate bench of court wide order dated 1/7/2025 had said first off, till date, the OP number 3 has not filed its statement of objections, let alone filed its power, let alone the statement of objections. First off, in a serious matter like this, non-filing of the objections next counter give rise to many doubts as to the credibility of OP number 3. First, next one. In the process, the last chance, call this matter on the 13/8. First, till then, interim order to continue.
Now, one more thing I beg to submit to your Lordship. Your Lordship may also direct 1 and 2 also to file reply.
How can I direct? If they want to file, they let them file.
They are the municipal authority.
Can the plaintiff?
I am insisting.
Should
Insisting. It has gone up to them already.
No, court, how can court say? You can take maximum advantage in the event they do not file the statement of objection. Let us see. But here is other party also.
Your Lordship, Your Lordship placed it on 13th. May I pray only next week if Your Lordship pardons my Lordship? 19th, like that.
19th.
All right,
19th. Entry model, Your Lordship has
Entry model to continue.
progressively.
70, please.
70, my lords, I'm for the opposite party.
Mr. Mishra, tell your friends also to make a contribution to the party.
We'll do that. We'll do that.
That will be a great.
I'll ensure that. The secretary was saying, I'll ensure that. Definitely.
70, my lords, I pray for the opposite party. I pray for some time to file the counter, my lords.
Counter?
My lords.
There is no period for counter whenever it can be filed.
No, my lords.
24 matter.
No. This inadvertently it has not been filed. So I take the
This matter
undertake that.
6th of September 2025. In the meanwhile, counter, if any, may be filed. Filling which, right to file one stands forfeited.
My lords.
And the petition amendments may be taken with the prima facie value.
My lords, in the meantime, item number 66 also I pray for the opposite party. I was told by my learned friend that your lordship has issued notice in my absence, so issued notice to the registrar.
Yes, because if panel counsel do not appear,
No, sir.
the university should appoint some other advocate.
I sincerely apologize. I was on my legs, my lord.
Think of that. Or panel counsel, government advocate, if they do not appear, we tell the government to change the panel counsel. Simple.
No.
Because there are many other competent youngsters.
No, I do.
They will get opportunity.
I do bow down to your lordships.
Item 71.
May I please, Your Lordship?
Yes, sir.
In this matter, my lords, the petitioner has prayed, has challenged the order dated 34/2024, in which OP number 2 had annexure 1 was appointed as principal in charge of the college.
Pagination is done now.
This business not in conflict.
Can we fix a date for hearing? Who is your
State government, higher education department.
education department? Do not file objections.
The file is not to.
They have filed the counter appeal. They have filed. I have also filed rejoinder.
May I please, Your Lordship? My lord, I'm appearing for opposite party number 5.
You one file to him, entire file.
Yes, I will.
Yes.
My lord, I'm appearing for OP number 5, my lord.
But on 20th of August.
My lord, the man is going to retire on 31st of July.
But what can be done?
No.
Because only 2 days are in.
No. I am conscious.
First of July.
It may not be possible.
May not be possible. Therefore, I put that.
I was playing only a short date.
11th, 12th. 11th of August? Okay.
Obliged, my lord.
73.
On this matter on 11th of August. Petitioner is going to retire on 31st of July 20.
On 12th, Your Lordship. Or on 12th. On 11th, I will not be there.
12th, you can have.
Item number 73, Your Lordship, I will take out notice on opposite party number 2 on fresh address, Your Lordship.
You have already taken steps.
No, Your Lordship.
You have to take steps.
Your Lordship.
Petitioner to take fresh steps with appropriate requirements within 2 weeks.
2 weeks, day after tomorrow, I will take out notice.
Within 3 days, 3 working days. Okay.
Obliged, Your Lordship. And counter to be filed by the opposite party number 3 to 5.
You take steps first.
Obliged.
Item 75.
Your Lordship. That should kindly have a glance to order dated 25/7/25, my lord. Wherein, my lord, this honorable court contended that the last date of admission is fixed to 37/25
you will obtain instruction with regard to admission. The present petitioners are the kid, the children who are entitled to admit in standard 1 class before opposite one number 6 school. The school in question having registration. These petitioners are selected on that school. Despite government has admitted, government has gave instruction to the school to admit the students. Despite several instructions, now the school is denying to admit the present petitioners who are kicked before Lordship.
Yes.
Tomorrow is the last date. Lordship kindly have glance to page 65.
You give opportunity to others.
My lord,
Why are you not taking it? You are for the school.
I am for the school OP number 6, my lord.
Yes.
On consent, I am appearing today. On consent obtaining from the previous council, I am entering my appearance today, my lord. First of all, the question to be decided here is whether Right to Education Act is applicable to unaided minority school. It has been answered by several judgments of the apex court as well as our own.
Give one.
And moreover, my lord,
Give one judgment.
in fact, 2000, it has been settled, my lord, since 2012 judgment of the Honorable Apex Court. By virtue of that judgment,
Give that judgment.
my lord, that judgment is a very lengthy one. What I was praying,
From first 8 pages you give.
my lord, what I was praying, I may be given a reasonable opportunity. I
The
will
last
highlight.
date is when?
No, my lord, section 15 of the RTA Act. Section 15 of the RTA Act, it takes care of that situation. May I read section 15, my lord? RTA Act, because RTA Act, that provision is not applicable to unaided minority school.
Read that section.
Section 2(4), my lord, 2012 judgment of the Apex Court. Pursuant to that, this has been amended. 2009
Read.
RTA Act.
Please read.
Section 1, subsection 4, my lord. Subject to the provisions of Article 29 and 30 of the Constitution, the provision of this act shall apply to conferment of rights on children to free and compulsory education.
Yes.
My lord, it was blanketly applied to all aided.
I have read that judgment which you are mentioning.
My lord,
We have held in Karnataka, we have held
my lord,
minority institutions are bound by this act.
RTA Act, my lord,
Because very amendment says. Kindly see that.
amendment, it says that, my
Up
lord,
to 2930, it is applicable to them also.
30 gives it is
Read
a
again.
fundamental.
Kindly read again.
Subject to provision of Article 29 and 30 of the Constitution, the provision of this act shall apply to conferment of rights on children to free and compulsory education. Article 30 guarantees.
You are a minority institution.
Yes, my lord. This is a minority, St. Arnold. St. Arnold.
But this petition was filed when?
Which petition, my lord?
This petition was filed on which date?
On
27.
27.
27, might have.
27 it was filed.
Yes, madam.
And notice was ordered on which date?
Notice was on
5th
25/7.
No, 25th we received the notice, my lord. We may be given an opportunity to file a reply.
Notice is on 16/7.
16/7.
My lord. But it was served on us on 25th by
Special messenger.
Special messenger.
No, on 16/7, my lordship ordered on 16/7 on Friday. That means on 25th the notice.
Special messenger was sent and with a notice that the matter shall appear on 25th. Then on 25th, the previous council will
Call it tomorrow.
My lord.
Prepare and file.
My lord, I pray for next week, my lord.
No,
I will file a
Request for longer date is rejected. Request made by learned panel council appearing for the private education institution for longer date is rejected. Since 31st of
I was reading that
31st of
my lord,
July happens to be the last day.
my lord, section 15 I was reading, my lord.
Call this matter.
Section-
We'll hear you next tomorrow. You file your objection.
Day after tomorrow, my lord. May I pray for day after tomorrow? Day after.
First, call this matter on day after, call this matter day after tomorrow.
subject to the condition that the respondent shall not plead the cutoff date of admission.
Section 15 takes care of that situation.
Let us see.
At any time, ultimately, if ultimately your lordship,
You should have filed the petition, objection right now. It's a very small matter, education matter.
grateful lordship.
Day after tomorrow.
My lord, day after tomorrow.
Yeah.
Grateful. I was praying that nicely, that would have been, I could have filed a short reply, my lord. Bringing on record all the relevant judgments for the consideration of your lord.
On 4th we'll have this.
My lord?
4th of July, August. Call this matter on 5th of August. Subject to the condition.
My lord, 6th, I have a difficulty.
Because they cannot take admission
No, my
elsewhere
lord,
outside.
15, that is what I was going to place section 15.
That's all. That will come to your ADs one.
Because why should I can deny it? If ultimately your lordship will pass.
We got the certificate of recognition. My humble submission is that school had got certificate of recognition.
But even minority schools also will have certificate of recognition.
Then how is minority school? He is claiming for minority, not that school is a minority
That
school.
is not applicable, my lord.
Anyway, he has to let him file objection.
Yes, ma'am.
What is the last date for admission in other schools?
Other schools already admitted.
Can be extended, my lord.
I-
There you have to be transferred to that school.
No.
No.
I am the opposite for priority of the school. Lordship page 30, Lordship can you have just, I am getting the priority.
My lord. Standard one admission, it's not a very, sorry.
What is the?
I am getting.
You are not yet admitted to any school.
No, not admitted.
Therefore, I am asking you, which is the last date for admission in other schools also?
That I will take instruction.
That-
I am giving the applied category. I have already registered. I am giving the applied category and selected this school. That is number one school is opposite St. Arnold School. I have already page 30 also can you see.
No, that question is whether this act is applicable to the minority institutions which enjoy protection under 29 and 30.
Yes.
Because section which your friend read now is subject to. What is meant by subject to? That we have to.
That your lordship has to.
Some courts have taken the view. Minority institutions are also bound by this.
Yes.
Larger issue is important. Therefore, just examine. Come up with some research papers. Or how various high courts have. It's a central act. You will have a lot of judgments from various high courts in this correction. Only thing is somebody should go to library.
Yeah. No, I have compiled the judgment. What I was praying your lordship, I will put it on record. And so that a reasonable.
Sixth, subject to the condition that the cutoff date of admission shall not be put forward by the answering respondent. Okay.
Item 78.
Your Lordship, item 76 is a twofold dispute. The petitioners are members of a cooperative society.
It go before the conciliation because this is for the nation conciliation, mediation, no?
It can be.
Wherever. See, this is a notice to everybody.
In the meanwhile, Your Lordship, if I may, in the meanwhile, it is my instruction that the dues with regards to the state government have already been settled by the society. Although I do not have any document because I am a member of the society and I did not have access to the same. If the said dispute with regards to state dues have been taken care of, the other dispute may be referred to mediation.
We can have that also there. If you have already paid, the dispute goes.
Lordship.
That's it. Refer to admission, the same order. You have made that now? That one, but you longer it is to appear because many matters you have sent that now. Some report will come within 3 months. That there we have 6 weeks, huh? 8 weeks. 8 weeks. What is to appear before the societies? Okay.
Item 77. In this item 77, in this matter,
27.
Yes, 77.
77.
Yes, ma'am. In this matter, the present petition is a disabled lady, widow lady. In her plot, one illegal bar is running, there's a liquor bar is running on that, and then there's a midtown, and the Tahsildar has already given a report, that is election one over here,
Not a case for mediation.
No, not case for mediation.
Exclude that. 77 to be excluded.
since counsel for on the submission of counsel for the petitioner, that it is not a case for mediation.
78.
78 is not a case for mediation, my lord. Your lordship has had an extensive this matter regarding pension matter.
79.
79, my lord. This is not a case for mediation, my lord.
What is this matter?
Pension and pensionary benefits, my lord.
What a matter?
Here I am for the accountant general in that case.
Item 80.
Item 80 is not a case of mediation, your lordship.
What is this matter?
This is a matter with regard to recovery. The petitioner is a retired employee, your lordship.
Recovery.
Yes, your lordship.
Not a case for mediation.
Item 81.
Your lordship, kindly fix a date, your lordship.
Mediation.
Let us see. Now in the for this,
In item 81 also, it is not a case of mediation, your lordship.
what is this case of?
I am praying for scale of pay of professor, your lordship.
Not a case for mediation.
Your lordship,
Not a case for mediation. Submitted at the bar. In that way, not a case for mediation. Let's be regular.
Pardon to mention, your lordship, in item number 76, the interim order may kindly be continued.
Not yet granted.
Interim order has been granted, may be continued.
In 77,
In 76.
76.
in 80, interim order is also there. In item 80.
80.
Interim order is also there.
It's there.
Yes, yes.
It will be there.
Yes.
Until this date.
Pardon?
Interim order is there means it is there.
Yes.
Now, why are you making that submission?
It has to be extended interim order.
Extension. Interim order to be extended. Finish.